bending the rules. She'd know it, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Hello, folks, and welcome. It's Friday. It's a very good Friday. Jesus Christ. Because, well, it's Friday. What a week. What a week of this absolute cluster F. But after the stream yesterday, I realized, yeah, I know, Mr. Steele with all those phone records. And it occurred to me that Mr. Steele is brilliant. And yeah, that is why he's paid the big bucks. So let me explain it to you, and welcome to the show. Yeah, as you saw, Mr. Steele explaining all these phone records, and it hit me yesterday after the stream. Jesus Christ, Nick, why didn't you get this earlier? Hello, folks. Hello, welcome. Why didn't I get this earlier? Well, here's the thing. No, that was the wrong one. There. The entire part of this trial that was about the bus shooting. The prosecution, also known as Miss Hilton and Miss Love, tried to make the connection between the guy who took the plea deal and the defendants here. And they spoke in length about the connections. And here what Mr. Steele did was explaining through this, the world's most boring cop, why this cop actually chose to not charge either Mr. Stilwell or Mr. Williams. There was simply no connections to make. Every phone call for months was turned down by Mr. Williams and Mr. Stilwell from Pee Wee, who desperately tried to get a hold of them. So this tells me that now I think the evidence against Pee Wee is very weak, but it tells me that he did something on his own in order to get back in good grace with Mr. Williams. This had nothing to do with Mr. Williams. The beef between Lil Wayne and Mr. Williams was more or less on paper only. It was what do you call it? It was a work, if you use a wrestler's term, as in we have heels and faces in pro wrestling, how they speak against each other to get the appearance of animosity and stuff like that. But Pee-wee is, how do I say this gently? I can't. He's dumb. He's not a clever person by any stretch of the imagination. He might have thought it was real, this beef. So he did this on his own. But as Mr. Steele shows here, let's play a portion of this. Dun, dun, dun. Let's play a portion of this.
You told the jurors, do you remember how long that call is? Approximately
535 seconds.
Give me an estimate.
So whatever that comes out to be, 60 seconds per, I think it comes out to be like, what is it, 8 minutes or something like that?
Yeah, just under 10 minutes. 10 minutes would be 600, so this is 535.
Yeah, so like 8.5 minutes, whatever it comes out to.
Sure, okay. Now that call that is on Ensemble Court's screen for the jury on State's Exhibit 133E, that is originally made, according to these records, 3 minutes after the 911 call. And
That's correct.
it's about an 8-9 minute call, whatever the five.
Oh, yeah, this is. I was meaning to go through this. Sorry.
And then the next one we have is item number 6173.
Wrong timestamp. That timestamp was the 911 calls. These are the phone records, which shows that Pee-wee never got a hold of Mr. Williams or Mr. Stilwell. They had nothing to do with him and had for quite some time. Goes through. Wait, wrestling verbal beef are fake? No, if it's real for you, Ghost Story. If it's And yeah, yes, I know, Valpal. There's Birdman who allegedly spoke with Pee-wee that night. Yeah, but in my opinion, they can't really put Birdman on that phone. In my opinion. But good point. But when it goes to, it might have been either Stilwell or Mr. Williams who just, Birdman, you deal with it. You deal with it. Or something of that sort. But what Mr. Steele does here during his cross-examination, although it seemed so dull for me at the moment, shows there's absolutely zero, at this point in time, there is zero connection between Pee-wee and Williams and Stilwell. Zero. Absolute zero. And how he does it, how he questions this officer, who I still can't remember the name of. He makes this officer his own witness on that stand. He gets him to agree with him over and over again, which leads to more or less the finale of it all, with Mr. Steele asking him, "You never brought charges against Mr. Williams and Mr. Stilwell, did you?" And he says, no, he did not. And now, then, after see here is the finale of. So let's go through that a bit.
If they're in a relationship or not,
Yeah.
I don't know. It wasn't, again, it's not the focus of my investigation.
Let me show you what, with the court's permission, what I've marked as Mr. Williams' number 224, and it's slide 5, I believe, from your PowerPoint. Do you know what I'm talking about?
The PowerPoint?
Yes. You do a PowerPoint?
Show it to the.
Yeah.
Show it to the state, please, first. Did you already show it to the state?
Yeah.
Okay. Ladies, have you seen it?
Yeah.
Okay, all right.
Of course they've seen it. They made him do that very PowerPoint. Oh, thank you, Ghost Street. Says, where did Fulton County get the idea to prosecute for RICO? Asking for newcomers who might not have heard your theory. Okay, my theory is you can't win elections with your ordinary home invasion, car theft, and stuff like that. And Fannie Willis, district attorney, up until a few months ago, wanted to go for the Georgia Attorney General position. And how do you get there? Through high-profile RICO cases. And you have a bunch of them in Fulton County. You have the former president one. You have this one against the young thug et al. And then you also have the 3 more unknown ones. It's one police, so-called police corruption one. You had one against another rapper who pled out just a few months ago. And then you had the 5th one is also, yeah, YFN Lucci. Thank you, Callie. YFN Lucci, who pled out. Here's the fun thing about YFN Lucci. Lucky? I don't know. Does this look like I know rappers? Now, they charged Lucci with 13 counts. 13 different counts under the RICO Act, which would have rendered him life in prison if convicted. He took a plea deal of 1 count. That's what they offered. 1 count, and he got a 10 plus 10. 10 years in prison and 10 years probation, with a bonus of time served. So all in all, he might get 6 years in prison, I think, with the cutoff thingy. So going from life to 6 years, that to me tells me this is the strategy for this for the district attorney's office. First, you have the Fulton County Jail, which is horrible. If you don't, I have another series about that called Fulton County Fails, regarding how they mistreat people in Fulton County Jail, how people die in Fulton County Jail. Yes, Kelly, they started all this going after teachers successfully years ago. Yeah. And if I do remember correctly, Fannie Willis was involved in that RICO case. Oh, we have good people. Thank you, folks, for reminding me about all of this. I mean, I've been doing this case. I've been covering this case for over a year now. Over a year, a year. I started in May of 2023. I started covering this case. I've been through it. I forget things that you remember. So thank you, chat, for reminding me of this. Yeah, but so Fannie Willis tried to get to the Attorney General's position. Now that kind of fails because she also chose to lie in church. She chose to using possibly public funds to take her boyfriend to Aruba, and who happened to be a married man, and helped him lie in his proceeding. And now it's getting really interesting. I had a video up yesterday about there's $500,000 missing in the Fulton County District Attorney's Office. Federal funds that should have gone to help open a youth facility. It's gone. Poof. Gone. $500,000 gone. That she got federal money to aid among the youth and stuff like that. And in addition to that, I will make another video. There's another $2 million missing that should have gone to clear the docket and help in SA victim testing kits that for a few years are still haven't been processed. That money is also gone. Where did it go? Well, apparently computers and travels and stuff. They just, federal money, give us. Oh, I want a new computer. $2.5 million just gone. That should have aided people in Fulton County. Allegedly gone. But when it comes to the election thing, yeah, Fannie Willis wanted to go up to the Attorney General's position, and RICO trials is how she wants to get there. Oh. Yeah, it's Friday, and Friday might get a bit spicier than usual. So if you have, yes, Cici, I have on a bonnet. I have on a bonnet. We got a lot of sun today, and the last few days, and my hair dried up a bit, so I'm trying to curate it. Yes, it's a whatchamacallit. It's a bonnet. So it's one of these. And because I am a very fabulous Viking, of course, I chose the golden bonnet. Kelly, she should get a RICO. Yeah, because this, I wouldn't be surprised at all if this gets to a federal RICO case against Fannie Willis. The probability of that is low, but I wouldn't be surprised. The Fulton County whistleblower is a great interview subject. Yeah, I agree. It will be very, very interesting. Good suggestion, Ghost Ray. But we're RICO trial. Okay, let's finish off with Mr. Steele's questions here.
Yes, sir, you may approach. Yes.
Yes, sir.
I just marked Mr. Wayne's number 224. For purposes of seeing if you recognize it or refreshes your memory.
And hit the like button. Yesterday you were horrible at pressing the like button. You need to improve.
Did I write this, sir?
Listen, if you don't recognize it, I know it's been a long time, don't worry about it. If it does not refresh your memory, just say it does not help my memory.
Yeah, I don't recognize this as being my work product.
Okay, then we'll just put it aside for the court reporter and just ignore that, okay?
Okay.
Thank you for looking at it. 224.
224, did you ever win 224 for identification?
Isn't it interesting that a work product, this is the lead investigator in the bus shooting thingy. He had no idea what that was. That was in discovery, provided by the state. So if he didn't do it, then who did? And where is that person? That goes to, where are the damn reports? We've been asking for them for quite some time. Where are the reports? Because the prosecution says, well, this guy is still an agent and he's a cop, Cobb County, He could find his reports very, very good. That one provided to the defense through discovery. He had no idea. So where did that come from, if not from a Fulton County report that the prosecution claims does not exist anymore, or they can't find it?
Okay,
No, it's been identified for the record.
all right.
Yeah, you identified it. You had no idea that this guy didn't know about it.
I want to go to the 1990, the Dolly or the sister, whatever you feel comfortable with.
Yes, sir.
Records, and we were in April, I believe. Is that your memory?
That's accurate, yes, sir.
When we broke. Okay. Now you talked about we were up to April 18th, and the real relevant dates that you focused on is April 25 and April 26. Fair to say?
That's fair to say. That was the main focus of the investigation. Yes, sir.
All right. So let's just go through this again, just showing the context, but I'm going to then stop at the April 25, April 26, okay? These are the context between the one that's on the board showing in State's Exhibit number 134E is at it's number 14091, and it's April 18, 2000.
Yeah. In the first month of this trial, they did have a hacker attempt in Fulton County. Yeah, they got one of these scamming attempts. If you don't pay us this amount of money, we will erase everything. Because somebody in Fulton County pressed. Oh, I wondered what this link goes to. Infect everything.
15, and it's the Dolly number or the sister number calling Jimmy Winfrey number. 3-second connection. You see that?
I do.
And that's next one is 418, and this is the same thing. No connection, but it's again the Dolly sister number calling the Jimmy Winfrey number. Fair to say?
Yes.
All right. The next one, again the same date, 418, but this is the Jimmy Winfrey number calling and connecting for 46 seconds, as far as we know, according to the records, with the sister's number. Right.
That's right.
All right.
Yeah,
We're getting
that
close
is
here.
Mr. Winfrey
Next one is
desperately
419.
trying to get a hold of Mr. Williams through his sisters, because Mr. Williams apparently wants nothing to do with him anymore.
Again, it's the sister's number connecting or calling and connecting 1 minute 59 seconds with the number to Jimmy Winfrey.
Yes.
Correct?
Yes.
All right. Now, again, 419, it's the same scenario. Sister calling Jimmy Winfrey 14 seconds, right?
Yes.
Next one is 420. And we are at a 34-second call. And again, it's the sister calling Jimmy Winfrey.
Yes.
The next one is a 3-second call, the same date, 420. Sister calling Jimmy Winfrey.
Yes.
The one after that is again later that same day, 2-second connection. Same situation. Fair to say?
Yes.
All right. Then we go to 423, and you have the sister's number calling Jimmy Winfrey. That's a 7-minute, 5-second communication, as far as we can tell from the records. Fair?
Fair.
All right. And then the next one again is later at 423. It's a 2-minute, 14-second contact, and that has Mr. Winfrey calling the sister.
Yes.
All right. The next one is the 15,003, 424.15, and that's a 1-minute connection, and it is the sister calling Mr. Winfrey.
Yes.
Now we're at 426, and we have to do the conversion for these records. Fair to say?
Yes.
So even though it says 426 at 306, you move back 4 hours, so we're really right before midnight.
11:06.
Okay, at night, 11:06 at night,
Correct. 11:06 Eastern.
and we're really on Saturday, the 25th of April. Fair to say?
Correct.
And that is the sister 2-second connection calling Jimmy Winfrey, right?
Correct.
Okay. And then they talk or try to connect, whatever the right word is, but the phones on the record show some sort of attempt later that.
This went on from the entire morning, with Mr. Steele over and over and over again, showing the jury through this witness, Winfrey barely ever he'd never got a hold of Mr. Williams, he never got a hold of Mr. Stilwell, so he tried other people who more or less told him to F the F off. We are not interested. You did a boo-boo, we are not interested. Allegedly, I don't know. They haven't testified. But that is how it seems to me. And I think, now, I didn't get that immediately, sadly, but I hope the jury was paying attention. I really do. And when I get to Atlanta in August, I hope to get so I can get into the courtroom, unless there's administrative. With my luck, they will have an administrative week that week. No, but if they have a trial day, I would try to get in there and observe the jury, if they have enough jurors left by then. So yeah, it will be really interesting to see how they actually react to the prosecution and to the defense. It will be really, really interesting. Let's skip ahead now to, then they have another break. Then they had a sidebar. And you know what that means? It is sidebar counter 179. Oh. But when the sidebar is done, it is time for Mr. Weinstein.
I'm just going to wait for a gentleman.
CC, hope I'm not talking 20th through the 27th. No, I will be in Atlanta around August 14 or 15. So I will be in Houston August 7 to 12. Then I will go to New Orleans, drive there, and then I will drive up to Atlanta. So I will be there 14, 15, something like that, August 14, 15. Then I will drive up to East Tennessee to visit Valhalla Awaits. And then I will go over to Indiana to be there August 17 or 18 to visit Delphi for the other case I'm covering, the Delphi case. And then I will end up in Michigan around August 19th for Michigan with going over to Wisconsin for the Zachariah Anderson case. I hope to be in Wisconsin because we are testing the prosecution's theory. If you don't know about the Zachariah Anderson case, he was accused and for some forked up reason convicted of murder, concealing a body, and stalking. In the prosecution's case, they alleged that he took a 6-foot, 270-pound man, rolled him in a carpet that was 5 feet by 7 feet, and carried it out to his van without any drag marks, without any blood droplets showing the carpet was taken out there. So here's the thing. I am taller. I am somewhere between 6'3" and 6'4", but I am 270 pounds. So we will try to make that attempt of putting me in a 5-foot by 7-foot carpet and test that theory. Because it's yeah. Yeah, I know. I will experience the southern US heat and humidity during the hottest month. Yeah, I'm the whitest guy alive. This here is 1,000 years of Scandinavian inbreeding. And yeah, it will be interesting to see how I survive. But there are large persons in Texas, I've heard. Tech Pro Academy, do you think the jury is thinking like us? I hope so. I would absolutely love, in the end of this trial, if there is still enough jurors, that they take 45 minutes of deliberations and comes back out with a not guilty verdict. That's my hope. Just to do to the prosecution for wasting their time for over a year. That is my hope. Now let's listen
Okay.
to Mr. Weinstein.
Be helpful.
Okay. Thank you so much, Agent. Your Honor, thank you.
All right, sir. Any further examiners? All right, Mr. Matthews, Senior, go right ahead, sir.
Oh, it's Mr. Matthews. Sorry, not Mr. Weinstein. Mr. Matthews, Senior.
Agent Racy.
Yes, sir.
Good afternoon, sir. Carrington Matthews here, represent Mr. Marquavius Huey. I have a few questions for you concerning cell phones. You've spoken a lot about your knowledge of cell phone information and evidence and investigations, correct?
Sure. Yes.
All right. You've talked a lot about call detail records in terms of, it gives us a lot of information in terms of when calls were made, correct?
Yes, sir.
How long the call took place, correct?
Yes, sir.
Let's kind of shift into text messages. You have knowledge concerning text messaging, correct?
Yes, sir. In reference to call detail records. Yes, sir.
Can you tell the jury how long, from your experience, text messages are available to be retrieved when under a subpoena?
Are we speaking about content or are we speaking about just the fact that text messages were sent?
Let's take them in categories. Let's talk about, first of all, let's talk about the text message itself in terms of the communication, not the content, but the communication. How long does that hang around?
Depends on the subscriber.
Okay. Do you have a range in terms of from subscriber to subscriber?
So we utilize a cheat sheet that I have on my desktop computer, but it's a work product that FBI CAST has put out, but it tells you each subscriber and their duration of time in which they keep those records. It varies from some subscribers for 1 year, or it could be extended more, a handful of years. They've drawn back over the last few years because the amount of text messages have been sent are larger nowadays versus 20 years ago, right? So it changes, but I'd at least say a year per company. They at least keep it about a year.
So the fact that a text message is sent from one device to another device, that actual communication or that print would hang around for about a year or so, correct?
And to be specific, we're talking about traditional text message utilizing service providers. And we're not talking about WhatsApp or encrypted applications, but just standard text message to text message. Typically, it's at least a year. Just the fact that a text message was sent. Yes.
Okay. Let's shift over to the substance or the content of a text message.
Yes.
Tell the jury how long would the content or the substance of a text message, how long would that hang around?
So it's pretty much not anymore. There's, they used to, again, probably years ago, when I first started my law enforcement career, you were able to get a search warrant and see content. Again, it was dependent upon company and there's a million different caveats in there. But over the years, as text messages grew, more frequent text messages than the actual are phone calls, people send more text messages. And so service providers stopped retaining that data. It's just too much data. There might be one company, I'd have to look at the cheat sheet, but there's one company maybe out there that retains it maybe for 3 days and you'd have to have a preservation request in or just get lucky with a search warrant within 3 days. But that might have changed since the last time I've looked at that cheat sheet. So from the outside, sending a legal process to a service provider, you don't expect to see content anymore in investigations.
Okay. If you actually, let's say you're investigating a case and you actually have a phone of interest, the contents of that particular phone, provided those contents are not deleted, they would remain in the phone. Is that correct?
So there's caveats in everything in investigations. First, you have to be able to have the physical device. Then you have to be able to access the physical device. Is it encrypted? What type of passcode? There's a million caveats in there. Is it a 4-digit passcode, a 6-digit passcode? Is it alphanumeric, 15-digit? There's a million caveats. But if you can get into the device, there's settings within your phone that you can have text message delete after 30 days. Are we talking about iPhones? Are we talking about Androids? There's so many caveats in there. But can you, in the perfect situation, get a phone, have the password, or be able to bypass the password, dump the text messages? Absolutely, you can do that. There's so many caveats, and we're speaking broadly, so I don't want to give an answer that locks it in, but that's only like one specific situation. But there's a lot of caveats. But yes, theoretically, you can get a cell phone,
right? So
get a tool and extract text messages. Yes.
Right. So if you have the password and you have the access, you should be able to have that content in that particular cell phone, right?
Again, there's a million caveats out there, so I don't want to lock in. The tool, the forensic tool that's being utilized, such as Cellbright or Axiom, they also have to have compatibility with that device. I've had it where I've gotten a search warrant, had access, but those tools aren't compatible with the cell phone. So there's inability to actually extract the data. Again, it's technology. There's a million caveats out there. But theoretically, yes, if you have access, you have a passcode, you have a legal process, it does fit, the software does fit compatibility with the forensic tool. Yes, you can plug it in, and yes, you can download that information in that scenario.
Now, in terms of tracking the cell phone as it relates to the phone's location, that obviously would play into where the tower is located in terms of where that the range of where that phone is going to be located. Correct?
Again, there's another caveat in there. So you have cell phone, what we call cell site, historical cell site data that tells you where the cell site is. And without going into it, a direction, an azimuth, a cell sector. But then there's also phone companies that do things called RTT, NELOS. And there's another one, I think PTT, I might be mistaken it, but RTT stands for real-time tracking. AT&T does NELOS. So for example, NELOS, AT&T, now more modern days, they will send a ping to your phone every 15 minutes. And so that is a ping. That is not cell tower data. So today, if I were to get a search warrant on an AT&T phone, for example, ask for cell site data and ask for NELOS data, I can get both cell tower, cell sector information, and I can actually also get those 15-minute pings, which is not cell sector. That is a ping on the device. So again, you're getting into the technology of it, but there's a lot of caveats in what we're saying.
So when you're having a conversation with your person that you're targeting, if you would, and you have their phone, you're looking through their phone, and when you know through your investigation, through maybe even a conversation with your target, that they are where they are located, where the alleged victim claims that they were meeting, cell phone evidence is less probative, correct?
I sustain the objection.
When it comes to cell phone technology and locating phones and tracking them, you're less concerned about tracking the phone when there's no disagreement about the location of the two people, correct?
I mean, I think I know where you're going with the question. So the value of evidence can change based off of certain external information, certainly.
Yeah. So if you knew these other phones were half a world away, you don't need to track them. So, but the prosecution asked you to do that after the fact, and that it's why it's so absolutely horrible. And by the way, folks, remember they had a big argument about this guy not be testifying about cell tower pinpointing and activity and stuff like that. The defense said, well, they need an expert. The prosecution says, well, he's not going to testify to that length. We have a cell tower expert that can. In this portion that is about the bus shooting, the prosecution, they didn't call a cell tower expert. Again, misrepresenting to the court what they were going to do. Ta fucking da.
I would just leave it at that. The value of the evidence certainly matters upon external information. If that makes sense, if that answer makes sense.
Okay. And basic good police work, if you have the phone in your possession of your target, you're going to more than likely print out those text messages if there are some, correct?
Not necessarily. Again, every investigation is different. I don't want to comment on every investigation everywhere all the time. It depends on, in my experience, I've been a patrol officer, I've been a narcotics agent, I've been a crime against persons detective, and now a special agent with the federal government. There's different types of cases, different importance of cases, the volume of cases. There's a lot of factors that go in there.
Sure.
So you can't box in and say you do this every time as a matter of investigative practice. I can't tell you that I do dump cell phones on every single case that I do. Even as a federal agent, I don't do that on every case.
Right. But if one of your parties is telling you that, just for example,
I sustain the objection.
if there's a conflict in the versions of events, you would certainly want all of the evidence that you can to. If there's a conflict in events, Agent Racy, you would want every medium of evidence that you can get your hands on in terms of cell phone technology to help clear it up in terms of whatever that conflict is, correct?
I sustain the objection.
Thank you, Agent Racy.
Yes, sir.
Any other examiners, defense examiners?
Here comes Mr. Weinstein.
All right, Mr. Weinstein.
Good afternoon, Your Honor. Let me just speak to the state for one moment. I'm going to need y'all's help to pull up the jail calls 140 EB, specifically the June 6, 2015, 1958 call. Okay, and you want to cue that up to 14 minutes, I think. Thank you for your help. Good afternoon, Agent Racy.
Good afternoon, sir.
It's good to see you again.
Yes, sir. You as well.
I have a question about your testimony from this past Monday.
Yes, sir.
Do you recall on Monday listening to a jail call with Mr. Winfrey from June 6, 2015 at 1958 hours?
I remember that, yes.
And do you remember testifying that you heard someone that identified themselves as Yak, or who was called Yak, state, quote, roll out the red carpet for Roscoe, unquote?
I do remember the red carpet and that, yes. Yes, sir.
Okay. What I'd like to do is I'd like to play the portion of that call starting when Yak gets on the call. And I'd like you to ask me to stop when you hear roll out the red carpet for Roscoe. Okay?
Yes, sir.
Okay. Okay, one moment, please.
People are telling me to. When I Google that, I get the only thing I get is a muscle relaxant, Duragetic. I don't get it. Okay. It's lost on me. Remember, I'm the whitest guy alive. It's not even a joke. This is literally 1,000 years of Scandinavian inbreeding. Hey, Ashton, welcome. Oh, durag. Okay. Well, I know it's one of these handkerchief thingies. Now, when I used to route,
We're going to play 140 Echo Bravo.
Sorry.
I believe this clip we're about to.
When I was a teenager, early 20s, I had a motorcycle. So I used to have a handkerchief tied, but then I had a helmet on to protect. A durag is not a bandana. Do men often wear bonnets in my culture? No. This is Megan Fox, not that one, not the other Megan Fox. Megan Fox, the writer. She nagged on me and then drunk me bought a bonnet, and I got myself a golden bonnet, and it actually does good for my hair. I mean, my hair is gray and quite a bit frizzy. I don't know the word for it. Well, and this guy, I do all the thing is to moisturize my hair, and then I put a bonnet on, and then my hair looks great. I'm not even ashamed of this cultural appropriation because it does work for my hair.
Play is the clip that I was looking for. If it's not, I'll stop it and we'll figure it out. Okay.
Sure.
Thank you.
Yeah, Roscoe, you did what the fuck I'm saying. I ain't doing shit, man. Just holding it down. Just got a sale on all these. Yeah, I go to court on the 16th or the 17th. But my lawyer, what the lawyer say when?
They were gonna try to get it dismissed this week.
They don't file for a motion. I was just calling to check on your ass. What you got going, man? Huh? Tell everybody I said what they motherfucking do. Hey man, you won't believe this shit, dude. Motherfucker got down Yak. Know this nigga got about 50 pieces of Yak and Malik on their bump, man. Little young nigga. He got a picture with Yak. What's his name? Hey, what little buddy name, man? Little light skinned boy. He be with little Bounce Simpson. The light skin. What that light skinned boy name with the dread? Peso. Yeah, Peso. Yeah, little young nigga. Yeah, we played up, man. They got the town. Huh? What say, bro?
Yeah, this is one of these jail calls they played when the prosecution in the direct examination of this witness. Somehow, this is in furtherance of a conspiracy.
You understand? You understand? You do what the fuck I'm saying? Hey, boy, you know, got your town on lock. Yeah, D4 ripping the hell, boy. You hear me, man? D4 ripping. Man, no bullshit, man. D4, no little motherfucker, man. No jump, no gotta slide. Man, they treat nigga like the Pope in here, man. Yeah, you know, your main motherfucker, man. You understand? Real, man.
Continue playing, Mr. Atkins.
Shit, I ain't talking about nothing, bro. Got nothing real. They just got them rhyme. I got a court date for that month at the beginning of the month. So shit, hopefully by then they let me out or something. Hey, right, yeah. Hey, make sure Roscoe good, man. I've been trying to get in touch with you anyway, so. Yeah, you know I got him, man. That's my man. You know I got him. Well, I'm gonna blow y'all nigga ass up, man. We'll sit right down when we get back to Roscoe. That what's up? What is?
Hey, yeah, you got your hey, yeah. These folks singing y'all music, bro. It's on God, man. These folks singing the music, man. The folks beating the whole wall down from 11 to 5 in the
Lucentiel asked, is the quote not in there? The prosecution only played small portions. Now, Mr. Weinstein is playing it. And spoiler.
Oh, Lord, you left out.
For Roscoe. Did you hear, even though you testified?
No time. Back for a major comeback, you did.
Okay. Did you ever hear, listening to it again, even though you testified on Monday that you had heard Yak say, roll out the red carpet for Roscoe? Did you hear Yak say, roll out the red carpet for Roscoe right then?
On this call, no.
You did not? Okay. Thank you. I have no further questions.
Touchdown. This is the prosecution. This is how they do it, because they believe that if it's mumbled enough, they can allege things through this witness. And now Mr. Weinstein played the entire jail call. He never said the quote that this guy testified under oath was in that jail call.
Any further defense examiners? All right, any redirect from the state?
Yes, sir.
Yeah, remember to hit that thumbs
Asia
up.
Racy.
Yes, ma'am.
And if you haven't subscribed yet, please do so. Helps the channel.
On cross-examination, Mr. Steele asked you about a phone number 504-723-5979. Do you recall that?
5979, yes.
Okay. And you said that it was a contact number for 504-319-2920.
Yes.
What does that mean for it to be a contact? Do you know what it means for it to be a contact number for 504-319-2920?
So it was just in the subscriber information as probably just a secondary phone number listed with the subscriber, with the provider, excuse me.
Now, do you remember when Mr. Steele asked you to look at specifically, I believe, the 1990 phone record, and I believe we said it's the sister of Mr. Williams' phone record, and see how many times that number called 3383? Do you remember that?
I do recall that.
And specifically in the month of April, there were several dates in which those two phone numbers made contact with each other. Do you remember that?
I do.
When looking at that record, if you remember, were there more calls between that number, those two numbers, on April 25th and April 26th than what occurred prior to those dates?
Yes, there was more frequency around those dates than prior to that, yes.
Okay. And on April 25th and April 26th,
Is that because Mr. Williams and Mr. Stilwell went, oh, hell no, get lost. And Mr. Wilfrey, I don't care, tried to get a hold of them through other numbers? Is that why? Might it be that's why? All of a sudden the frequency to the Williams sisters increased? Maybe, just maybe.
Was that the night in which you were investigating?
That's correct.
Yeah, I'm bored. Let's see here. He's still on the stand and they have a break.
Okay. The whole premise, Mr. Steele, is that it's self-serving at this point in time for you to be able to elicit that particular information. If
Let's see. Now, the jury is gone yesterday. So, now they are having a fight. Well, not a fight per se, but they're having an argument because Mr. Steele wants to introduce some things to counteract. But Mr. Glanville says it's self-serving and not proper. Not a proper time. It's not self-serving. It is impeach. Yeah, let's just listen to it. I will go up to 1.5.
yes,
I would like to, where the agent leaves, ask him questions about topics that would be under the rule of completeness. I heard what you said. I respect what you said. I'm not trying to get the ire of the court. I'm not saying you're upset. I'm just saying, to me, it's relevant right now. Like, for
Mr. Steele, sir, can you step outside for a second, please?
And again, he doesn't allow any of the defense except Mr. Harvey. Glanville shuts up when Harvey speaks for the most time. He doesn't interrupt as much. But always he will not get... And this is quite infuriating because often when you stand in front of a judge and you make an argument, you have a trail of thought, a trail of logic that gets you to a conclusion. You need to get there, especially if it's an oral motion to get a piece of evidence accepted. Mr. Glanville happily does that to the prosecution. He even helps the prosecution get the right argument. But with the defense, you saw, Mr. Steele, what did he get? 10 seconds in before interruption.
Stand fast. Okay. The whole premise, Mr. Steele, is that it's self-serving at this point in time for you to be able to elicit that particular information. If and when you decide that you should call or wish to present a defense on behalf of Mr. Williams, then I will make rulings as to the rule of completeness and other grounds. It's just not.
Rule of completeness is on the actual subject. It doesn't matter if it's the prosecution's case in chief or the defense case in chief. If the evidence is not complete, you can apply the rule of completeness at any point in time. You cannot, Judge Glanville, do what you just did to claim you can't do this until it's your case in chief. That's plainly wrong.
Presentable now. I'm not saying you can't, but I in no way want for you not to understand, for the court to impress upon you. You don't have the right, you don't have the responsibility to present anything right now. I know you told me, well, it's going to be 7 months before we get a chance to do that, to elicit this particular evidence, but the court recognizes your right at this point in time to not present anything and the burdens of states. So we've covered that in great detail a number of times. I'll give you a continuing objection on the issue, but that's my ruling at this point.
Can I understand? Can I just give one example and then I will do it in writing?
So you're still going to ask me at this point in time even though we've covered the same issue at least 7 or 8 times at this point in time, because you made this point at critical junctions that you believe are important. So
maybe because you keep making stupid rulings, Glanville. Maybe that is why he keeps bringing it up, because he still has to preserve the record for appeal. And in this, under the RICO Act, every portion is a separate underlying act or overt act. If he does not make sure that his objections are clear for each overt or underlying act, that might not, it's just a precaution. It's a belt and suspenders kind of thing.
I'm fully aware of the issue. I really am.
Well, okay, I will put it in writing. It's just to me, when the state, this is what I want to say. I'm going too far. I'm not trying to waste your time. Or anyone's time. When the state says, you notice that there was a beef, I think that's the word, between the answer is Lil Wayne and Young Thug or Jeffrey Williams. I believe that under the rule of completeness, I could put in a statement of Jeffrey Williams on July 15, 2015 with this detective, excuse me.
Yes, you can. And to quote a famous politician, yes, you can, but you just can't do it now. Okay.
Now I'm going to obviously go with it.
Okay. Yes, you can, but it's just the law doesn't provide you the ability to do that now because it's self-serving. Okay.
I'm not
It's self-serving but like I said, if you make that decision at some point in time and at the appropriate time that you wish to do so, then I will, of course, then that.
Yeah, exactly, Kelly. Hold on, where I find it. The witness is there right now and is talking about it. Now is a proper time to do it. But the judge, oh, you can bring it up later. Bring your own witness. No, this is the prosecution's witness who claims there is a beef. That should also mean that he needs to be impeached on this. And the way to do it is through statements of the party involved. That is not calling Mr. Williams to the stand. That is impeaching this witness with a contemporaneous statement. But here we are.
Point in time permit or allow you to present that particular evidence at that point. Okay.
I understand.
Okay. All right. Yes, sir. Yeah, it's continuing, sir. Okay. All right. Can we call Detective or Agent Racy back? Someone like yours. Okay.
No. And
I'm sorry, Your Honor. Hold on.
now we are into cross-examination after Miss Hilton tries to, whatever. I mean, I skipped over it because most of the time, the prosecution's direct examination or a rebuttal are not interesting. The most interesting part in how they claim or how they make this guy testify is heard again in cross-examination.
Second, please. May I step back, sir?
Sherman's view. In my culture, we call our head wear a bonnet. Yeah, I know. I got one. Our beautiful black American women use them to hold the moisture in their hair. I do it too. I had no idea. If I knew this existed 30 years ago, I would have used it. Thank you. But for you who are completely new here and wondering what the F is this white guy doing, let me just show you. Let me just show you. Hold on here. I'll show you. I'll show you. Ta-da! This is why I have the bonnet, okay? All right. So I don't care who invented the bonnet. Thank you. Thank you. Thank you, Cece. Thank you. And now recross from Mr. Steele. Skipping ahead.
Yes.
It is a sidebar. It is a sidebar, which brings us to sidebar counter 180. 180 sidebars. 180 sidebars in this trial. We are 6 months in. Well, almost 6 months in. And it says, I know, this is trial day 78. It's not really. You can remove 10 of those days as days with they only have hearings and stuff like that. Now we're down to 68 days. Then you have all the half days. Remove another 6 or 7 days. Okay, now we're down to 62, 63 actual trial days. And I don't even count in the amount of times the judge is an hour late in the morning. He takes 90-minute, 1-hour lunches. His 10-minute breaks are always at least 20 minutes long. So actual trial, I would, at most, in almost 6 months, they have had maybe 55 actual trial days in almost 6 months. Ooh, let's skip through to when they get back from the sidebar. There.
Please.
Your Honor, based upon this honorable court's ruling, I will have no other questions for now, and then I would like
Indigo
to have the
Luna,
court.
I haven't seen you over here for... welcome. Hi, Indigo. Everybody say hi to Indigo. Hello. Let's see here. There's a discussion. People like Nick are finally able to shed light on the hypocrisy of the court system. Yeah. My goal here is, I yell at the prosecution. I yell at the judge. I sometimes even yell at the defense here. But it's just, I want everybody to do better. Because if the justice system fails, then nobody is safe from wrongful prosecutions. We need transparency in the court system in the United States. Remember, I'm over here in Sweden. In the European Union, we have zero transparency. If I want court documents from a current court case in my jurisdiction, I have to wait until the trial is over and apply for transcript, and it can be denied me. And I have a law degree. I work in this jurisdiction. That's the lack of transparency we have here. Imagine that lack of transparency in the United States with the jury system and everything. You do not want to go in our direction. You need more transparency to hold public officials accountable for fuckery, okay? And hopefully my little channel makes a small, even if the smallest dent in aiding that. I've done my job. I have done my job. If even the smallest dent, when the government tries to hide and sneak things from us.
Not excused.
Okay.
The agent.
Any other examiner for recross? Any other redirect? All right.
Yeah. This was Mr. Steele saying, we want to have the opportunity to recall this witness. Because this is one he really wants a second shot at during the defense case in chief, and I understand why.
Agent Racy, you are going to be subject to recall. So please don't discuss testimony of anybody except the attorneys in this case, okay? But I'm going to release you for now. We'll give you enough time if and when that should become necessary. If I can have you all come back for tomorrow morning, we go and then. All right. Let's go through our customary admonitions. Remember, leave you know what's been lawfully presented within.
As you see, there's an hour and a half left of yesterday. This.
Okay. Given the fact that Ms. Latner is going to rejoin us, the issue of the.
Yeah. Today, we will get there. Miss Latner is back. Miss Latner is the person who has, what you call it, what's the name of it? Well, she controls the paperwork. What can I say? What's the word I'm looking for? Yeah, 911 dispatcher with responsibility for a lot of things. She's been on the stand before, and she's custodian of papers thingy. She's been on the stand quite a few times already, and she's quite annoyed being recalled over and over again. And we will get there in this recap.
CAD reports, is that going to come up tomorrow?
Yes.
Potentially?
Yes.
All right.
And
And what other issue do you have for my consideration?
So that was half of the first one, that we were entering into another series of acts, starting with January the 6th, going through January the 10th. So that's one portion of it. The second, I think most pressing portion, however, Your Honor, is the fact that we would be asking that the court release Agent Racy from the state subpoena. He is making himself available to be subpoenaed by Mr. Steele if he so chooses. But if he were to not appear, the state would not be seeking a material witness warrant, because we were not planning on calling him again. Just to make it legal and proper, we would ask that the court require, if Mr. Steele plans to call Agent Racy in his, or if he so chooses at some point in the future.
Oh, this is so sneaky, because they really don't want to have him back on the stand, because they saw what the damage Mr. Steele did during his cross-examination. So now they are trying, well, if he really wants him back, he should be released from our administrative subpoena, and they have to subpoena him. That is so sneaky.
Sure. That he just put a subpoena in his hand.
Okay, I've made that decision. I'm going to go ahead and just leave him under subpoena at this point in time. Okay. Given, but I've already stated for purposes of the record that that's if Mr. Steele and his client decide they wish to present a case, then the court will make him otherwise available, given the issue of his federal subpoena and availability.
Oh, and I don't think that he requires a 2E letter. He didn't require one.
Okay.
As long as he's being questioned about his Cobb County, about this case.
Yes.
He does not need a 2E letter. He does not have to, Mr. Steele, or no one else has to go through those steps.
All right, so I'll leave him under the subpoena at this point in time. Now, if Mr. Steele decides he does not wish to present a case, which he can make that decision at some point in time, if that's the case, then I'll release him at that point in time. Okay? All right. What else did you wish to ask me?
It was only to tell the court that we.
Yeah. Sorry, Miss Love, that didn't work, because that means extra work for him, Mr. Glanville. And he really don't like the extra work, because releasing him from the state letter of subpoena, whatever they call it, that must be administrated and stuff like that. And then the defense have to submit a subpoena, and he doesn't. So, and he already, on the record, he already said, you are subject for a recall. So he really can't.
We're getting into another series of acts. This was the January the 6th, and then January the 8th. These are those series of acts that we intend to introduce evidence of, and those are the ones that the CAD reports pertain to.
Yeah. So, Mr. I keep forgetting his name because he's a dull person. That witness was the last witness of the bus incident. Now they are moving on. And as I said in the beginning of this stream, this prosecution said, oh, we will get a proper cell tower expert on the stand. Apparently not. Ha!
It was just an announcement that we were entering into a different series of acts.
Can I ask the state a question about tomorrow?
Since you've already risen and.
Yeah, I know. I'll go ahead and do it.
Do it.
Are y'all planning on introducing the booking report tomorrow on Mr. Kendrick?
That, Your Honor, that is a possibility, yes.
Okay.
So that would be 3 witnesses, and the third would be Lieutenant Bobbitt from the Fulton County Sheriff's Office.
I'd be requesting some redactions to that booking report.
Okay.
Would you like me to put those in writing now, or you want to address them later?
Your Honor, we can speak with Mr.
Offline.
Weinstein.
Okay, great. That's fine. Thank you.
If Mr. Weinstein, you just-
And it's good that he does this now because he knows it's on. They are still on the record. So the defense is starting to learn, get things on the record, because whenever they do the email thingies, sometimes emails get lost magically from the prosecution. So it's a good thing that Mr. Weinstein does things on the record. And let's see.
006-0294, which is 2 pages, and I'm sorry, 3 pages, and it is labeled State Exhibit 1 Tango Alpha. Office service for incident number 15006-0299.
This is Miss Love entering evidence properly into the record to the
Incident number 15008-0094.
court clerk.
It is a.
This is just administrative stuff.
One
We can skip through that.
additional thing, for Mr. Shard, if they've received the exhibit list, the CAD report for exhibit 2Y or 2 Yankee will be in the Dropbox link that was provided last week on,
I hate that they use Dropbox. You know why? Because then the prosecution can see what files they are accessing and when. I hate that with a passion, because then they can prepare and counteract. And when they know, oh, they didn't access that one until very late, let's focus on that one. So it goes to strategy. That is, oh, I hate it.
last Friday at about 5 o'clock p.m. Everything else will be in that email I just stated.
Thank you, Ms. Hilton.
And there's another little break.
One of these events, as I
First go answer.
assume others will make the same objection.
Yeah. Now comes Mr. Harvey. Mr. Harvey is a very seasonal. He has some years to him, and I'm grown more and more to respect him. I mean, in the beginning of this trial, or just before this trial started, he had an hour lecture about the Second Amendment and how every gun-related crime should be excluded from this prosecution, and he did a great argument.
The aforementioned documents is referenced by the state from.
I should try to find it again and make a cutout so you can hear it yourself.
So I
It is
believe,
an
Mr. Harvey, you
amazing
indicated you
lecture.
want to have discussion on this, so I'll let you have the first go answer.
I assume others will make the same objections or add when I fail to include everything. My recollection was that these incidents were mentioned as course of conduct during the course of the investigation to explain perhaps the course of the investigation. I recall that everybody joined in a objection to the admission of each one of these, and it's a January 6, 2015, to January 6, 3. Third is January 8th, 2015, 2 of them January 8th, then January 9th, and January 10th. I think we made objections under the old case Teague versus the state at 252 Georgia 535.
252 Georgia 535?
Yes, 534, sorry.
Sir?
The newer case is Davis versus the state at 307 Georgia 746.
307 Georgia, what, I'm sorry?
307 Georgia 746.
Okay.
The objection was course of conduct is still hearsay. The second objection was confrontation, and I'll get to both of those in a minute. But each one of these events, as I understand.
See how Judge Glanville is listening? Doesn't interrupt. I mean, Fulton County Court have a Harvey rule. This is Mr. Harvey. As in, if you have multiple defendants and who have their own attorneys, if an objection is made, everybody's in on it unless they opt out of it. That is the Harvey rule. This is Mr. Harvey.
Understand it, and y'all can correct me if I'm wrong, are unindicted acts to explain the course of the investigation. I believe I joined in the hearsay and confrontation objections. I also added my, hey, prejudicial spillover. This is getting way beyond anything that Mr. Nichols may be responsible for at this particular point. And if it was being admitted solely for the purpose of showing the course of investigation, but not for the truth of the matter asserted, then I asked for a 105 instruction. I don't believe that any of these can be admitted for the truth of what happened, because we don't have the right to confront any of these people. And these are testimonial statements because they're coming from individuals to law enforcement. So as to each one of these, on behalf of Mr. Nichols, I maintain my objections to each one of these non-indicted acts that were originally admitted for course of conduct over objection. And now we have additional CAD reports that are coming in that have nothing to do with Mr. Nichols. So I renew my motion for severance. I renew everything that I've said before. And if they come in, please, again, I'm asking for a 105 instruction. So help me out here, folks. That's it.
Okay, sir. So you're asking for severance and a 105, is that right?
Asking for three things.
So that's what I wanted to make sure.
Yes. Okay. Number one, to prohibit the admission of these, especially for the truth of the matter asserted.
If they're admissible, man, let me just ask that. If they're admissible, you wish the court to give a 105 instruction. What else?
And renew my motion for severance.
Okay.
Based upon prejudicial spillover for these unindicted acts coming in from 9 years ago.
Okay. All right, sir. I'll note that. Just give me a second until such time as I've been able to consider that. Okay.
CC says, I don't know how true, but I read Harvey is the highest paid lawyer at this trial. Mr. Harvey only takes, I mean, he really doesn't have to work, but he took on this. I'm not sure if I do believe, I've heard when he takes on cases, yes, he is insanely expensive. But then he does the discount thing. He'd have this extreme high rate to scare people off, then he gets discount in, so people don't actually have to pay that much. That's the rumor. I don't know if it's true, but yes, he is the one who has the highest hourly charge of the bunch, followed by Mr. Steele, Mr. Shard, Senior. So I mean, it's been a few months since I saw this, but yeah, I've grown to be very, very fond of Mr. Harvey. And the reason why he keeps asking for a severance is that Mr. Nichols is mentioned once in one count in the RICO Act. Once. So why does he have to sit through all of this when there is 196 overt and underlying acts in the RICO Act, in the RICO charge, when he is only mentioned once? But the judge keeps denying it.
interviews with various people of interest during the investigation of the case that allowed law enforcement to go back to the January 6th date. At that time, there was a fight at Club Crucial. And after that fight, shots rang out and defendants Martinez Arnold and Diamante Kendrick were stopped speeding away from the location where the fight had broken out and shots had been fired with an orange cone caught underneath their car. At the time that they were stopped, they, I believe at least Mr. Kendrick ran and was subsequently apprehended. He got out of custody on the 8th. And on the 10th, when Donovan Thomas's murder occurred, there were calls made from the jail by Mr. Arnold to persons outside the jail, which who were in the presence of Mr. Kendrick on that night. The 2 CAD reports relating to the January 6th.
By the way, I'm playing this in 1.5 speed. Imagine how boring this would have been if I did. I'm going to get more and more into recaps because there's so much downtime and so much boring stuff in this trial. So I will go over more and more to do more recap things, to condense it down to something that makes it interesting.
Incident both involve a fight in progress and then subsequently a fight with a weapon. So the shooting that occurred after that was related to the fight inside. So it's not to explain the course of.
Okay, I was going to say, but what's your theory of admission for these particular records?
One, as to the admissibility of them, I would cite for the court Kamasoko, and that would be Kilo, Alpha, Mike, Uniform, Sierra, Oscar, Kilo, Oscar versus the state. 362 Georgia App, 276. And in Kamasoko, the court addresses the admissibility of CAD reports, notwithstanding the defendant's or the appellant's assertion that the trial court erred in denying his motion in limine seeking the exclusion of the police dispatch reports or CAD reports, claiming that the state had failed to establish they were admissible under any exception to the hearsay rule. The court, turning first to appellant's argument regarding hearsay, concluded that the trial court did not abuse its discretion in admitting the CAD reports into evidence at trial under the excited utterance exception. The court went on to address that the statements made during the 911 calls about officers reporting to
blah, 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 blah. Blah, 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 blah. Let's see.
Present sense impression, but definitely excited utterance.
Yes, sir.
So I also would like you to look at footnote 3 of that opinion, if you don't mind, Your Honor.
You mean Kamasoko makes no distinction between any particular statements or declarants?
Yeah.
Okay, I'm with you.
And therefore, he did not preserve the issue for the appellate court to rule on. But what I thought was interesting to our discussion is the next sentence after the Hunt HUNT decision is mentioned. It says, in addition, if you see that, Your Honor.
Yes, sir.
Although Kamusiko mentions in passing that whatever was said to the 911 operators was filtered through people who did not testify at trial, he fails to include either citation to authority or meaningful legal argument that the CAD reports were admissible because the 911 operators or other persons writing down the declarant statements did not testify at trial, therefore he abandoned it. The reason I do that is my understanding, Your Honor, what the state is trying to do with these specific exhibits that you mentioned is, that we mentioned earlier, is put in the actual written document, but without the 911 call, without the 911 caller. How are you, as the finder of the law, supposed to say, yeah, this is an excited utterance or a present sense impression? All you have is a document. You don't know if this was an hour after it. You don't know if the person's laughing on the other end of the phone. You don't know. We don't know anything, and that's my problem with the admission of all this. This is just a trial by a document without a witness, without even the 911 call, which 911 call don't have the witnesses, but at least you have, like you did earlier in the trial, you can say, hey, this is confrontation clause under Pitt, so this is not, this is just hearsay. So I just want to point that out to you. I don't believe that it's admissible without.
Thank you, Reformed Convict, for your $5 super chat. I appreciate the enormous amount of time you spend on this trial, my Viking friend. I hope your channel rises to the top. I hope so too, and thank you so much. These occasional super chats and people becoming members that is what keeps this channel afloat and allows me to get new stuff like the new microphone and the new I got a camera just a couple of months ago. It's a 4K camera. I don't use the 4K because the frame per second gets lower, but hey, improves the channel. Hopefully I will get, yeah, just as long as I can keep this channel afloat so it pays for itself, so I don't have to pay for it, because some days I spend 9 hours on streams, and I make $30. So yeah, if you wouldn't mind, at least hit the thumbs up, subscribe if you haven't. I'm fine, because sooner or later I see on the huge channels the revenue will get there. I'm fine with putting money in myself with the help of the occasional super chat and membership, as long as I see, yes, sooner or later this channel will pay for itself, and it might even make me a bit of a profit. Thank you, Reformed Convict.
More context, because all it is the CAD report, as Ms. Latner has said many times, it's just another person who is filtering information from the police and from the 911 callers and going back and forth. So we really don't know.
Okay, so your specific objection is to the reports themselves.
Yeah, I mean, without the 911 calls.
What about the 911 calls themselves?
They don't have them.
Well, they got calls in 2 Yankee Alpha through 2 Yankee Golf.
Then it's the same thing we did earlier.
Sorry, let me correct myself. 2 Yankee Alpha through 2 Yankee Echo. There's a series of 5 audio 911 calls.
You need to make the call. Is it admissible or not under PIPs? You know, we went through that whole ramification, whether this is to catch somebody, and is it a crime that already.
Thank you, Vamp, for $10. I bet they're hungry on that, but oh yeah, the jury, $25 a day. But the judge at least ruled that they get paid even on administrative days when they only have hearings. So but it's still, seriously, they don't get paid lunch. They don't get their travel expenses reimbursed. All they get is $25 a day, and that should cover for everything. If you want in my opinion, if you want the jury system to actually work, people should not go bankrupt sitting in a jury. This is why people try to get out of jury duty, because they know they risk going bankrupt.
Is it a present sense impression or not?
Versus, is it confrontation clause? You know, just like in PIPs.
Thank you so much.
He has a parole hold that goes in PIPs. He has a parole violation.
Yeah, okay, yeah, but
you got to excise that.
I understand.
That's
my passion, expertise will surely take you to the top. Yeah, thank you so much. I hope it will. I hope it will. When I made a statement in August of August of last year, I will cover this gavel to gavel. I had no idea. I thought this would be a 6-month trial tops. Well, that's now, and we are not even halfway through the prosecution's case in chief. But when I made that promise, I'm going to keep it. I will follow this case from gavel to gavel.
The point is, we have no witnesses here. There's 0 witnesses for these events, and I don't even know how it came in, except the state, argued successfully to the honorable court, hey, that goes to my investigation. But they need to bolster this some way.
Well, here's the thing with Davis, which Mr. Harvey, that's it. Yeah, that's it. All right, Mr. Harvey referenced to the court, which is the successor of T. But Davis kind of indicates to the court that
indicates.
By T, I should say. I apologize. Applying the rule in T, we held it as error for the trial court to permit the state to elicit testimony from the investigating officer as to a conversation that officer had with a third party for a limited purpose, to explain the officer's conduct in continuing the investigation of robbery because such information was not relevant to determine the defendant's guilt or innocence.
I've argued that, right?
However, we've ultimately affirmed the defendant's conviction and they're holding it was harmless. But the court goes on in Davis to indicate that they talk about the investigatory actions need not to be explained. And in that particular case, because of the investigation was not attacked, all right? However, In terms of, and you mentioned footnote 3, that Davis also contends his testimony violates his right to confront accusers. This argument fails for a simple reason that Lynn did not testify to the substance of what any of the more than 30 witnesses told her.
But that's where we get this. Yeah, that's exactly what I'm saying.
Yeah, so as long as they're not stating, that particular issue, or not, not admitting those to violate your confrontation clause, then that certainly would be appropriate. However,
I mean, $25. Can you,
I'm going to pause on.
at this inflation rate, can you even get a Happy Meal for $25 in the end of this trial?
The CAD reports themselves. That's the ones 1 Tango Alpha Bravo, 1 Yankee Alpha 62. Lima Alpha and 62 Lima Bravo, and 1 Yankee Bravo and 2 Yankee at this point. But let me listen to the 2.
Yeah, and then they talk and talk and talk and talk. So let's go to today. Let's see here. I will catch up on it.
Seeks assistance in the face of immediate danger.
Let's see here. Dun, dun, dun. Dun, dun, dun. And a swoop. We need a swoop. My swoop is the Norwegian fire farting dragon. All right. Let's see. Here.
All right, I've also had an opportunity to consider Carlson's Guide to Evidence Authentication, 3rd edition, chapter 15, subpart 03, pertaining to 911 calls. A recording of a 911 call frequently qualifies as an admissible excited utterance. And when a 911 call is made to avert a crime in progress or seeks assistance in the face of immediate danger, these circumstances can merit introduction into evidence. And it cites for that proposition United States versus Vasquez, 763 Fed APPX 136 Second Circuit, and also United States versus Mitchell, 726 Fed APPX 498. In taking a look at Pitts, that was the first case where our Supreme Court, Chief Justice Sears, writing for the court, basically.
Exactly, Lucentil. Great point. They are not admitting the calls. They are admitting reports about the call. That is not excited utterance because we don't know how the actual reaction was on those calls. When they're talking about it in the Pitts case, they are talking about the actual 911 calls, not the reports. Why? Because reports is the officer's interpretation. That is hearsay. That doesn't go under the excited utterance. It should not. It should not. Yeah, I saw Gavin McTin video released of P. Diddy, and that is a quite severe assault. Quite severe assault. And it shows that his ex, yeah, she's probably telling the truth.
Adopted the majority view of depending upon that these types of calls need to be made or determinations need to be made on a case-by-case basis. The court, in taking a look at the phone calls from 1 through 5, is of the opinion that they fall within the excited utterance category. But Mr. Weinstein, I'll let you perfect your or if you have any additional argument on the issue, I'll be more than happy to consider it.
Thank you, Your Honor.
You got 5 minutes.
I won't need 5 minutes, Your Honor.
All right. Okay. All right.
You can put the timer on. Regardless of whether the calls are an excited utterance, and I understand how the court could see that, given certainly perhaps calls 1 and 5, there's still the issue of Pitts and Crawford. The calls are testimonial in nature.
How are they testimonial in nature? Here's why. Let's have a conversation.
Sure.
See, he gave Mr. Weinstein 5 minutes for his argument. What did you get? 10 seconds, 15 seconds. Oh no, let's have a discussion about it. No, you're now, I know you're allowed to, but you should hear him out first and then go through the problems with it.
Have a conversation.
Love it.
This is a 911 call, a citizen-initiated call, and it is somebody who is in a state of mind telling about somebody who needs medical attention. And it's clear that from the call, from those series of calls, that's what was undergoing at that point in time. So it's different than if you were to like initiate or take an interview of somebody. These are citizen-initiated calls. So why would you say that they're testimonial in nature?
Okay, I agree with everything you've said as to the nature of the calls, but all those calls are taking place. And if you look at Pitts, one of the tests is it a call after a completed violation of the law? And
But that's only one issue. The issue is, what was the call made for the purpose of? It was made for the purpose of seeking medical attention. So you're reading it too narrow, sir. It's an or.
I disagree that it's an or. I understand the court's position.
Or is disjunctive, right?
An or is disjunctive. I do remember my schoolhouse rock.
I do remember the or may not necessarily be disjunctive, but in this case, I'm going to read it as a disjunctive.
I understand, because I read the or in Pitts, and I saw it as either a completed violation of the law or to assist law enforcement in apprehension of the perpetrator. It seems to me that, sorry, not the or there, but I think these were made in order to report a completed violation of the law, which is one of the tests under Pitts. They're to assist law enforcement in apprehending a perpetrator. They clearly have testimony in there. And
the primary purpose of that particular call, the primary purpose of that call, you can tell just from the nature of the call, is that you got a shooting. You got somebody who is very insistent on getting an ambulance there, and they're talking to the person that's been shot, which is the present sense impression. So how can you say that that's for the purposes of, for the primary purposes for prosecution?
But how can you say that when you look at Pitts' test of reporting a completed violation of the law, that's not what's going on there? They're not under present danger, which is another one of the, I believe, tests in Pitts. They're not in immediate peril at that point. So that's not what the call is for. And I'm worried, I'm a little concerned. I want to make sure we keep hearsay and the confrontation clause issues separate, because I understand that what you're saying about excited utterance, which is a hearsay issue, but I don't believe that's a confrontation clause issue.
Carlson goes on to discuss, and there are several cases that bear this out. Excited utterances violate Crawford versus Washington, which is 541 U.S. at 36, 2004. The Crawford decision requires that most evidence employed by the prosecution in a criminal case must be cross-examined. Since the excited utterance speaker in Rule 803.2 situations is generally not cross-examined, does the admission of his or her statements violate Crawford? No. I mean, not if the speaker was in the middle of the crime situation and calling 911 for help. And that's it's like Dixon versus State, 996, I guess, second.
Yeah, but that is what Mr. Weinstein is arguing. This is not in the middle of the crime. This is after the fact 911 call. But the judge just refuses to listen. And then, shouldn't Love be arguing this instead of the judge? Exactly. Here's the thing. The judge is supposed to be the gatekeeper. The state argues, the defense argues. If the state brings a motion, they get to talk, the defense gets to speak against, and then the state gets the final word. If the defense brings a motion, they speak first, rebuttal from the state, and then final words from the defense. And then the judge will make his ruling based on their arguments. Now, the judge is doing the prosecution's work for them. He's researching case law in order to get prosecution's evidence in. That is not gatekeeping, in my opinion.
1271. So, and then it's distinguishing from narrative statements made to the police, which would, in fact, need to be tested under a confrontation clause analysis.
Okay, Your Honor, I understand, but they are not, and I think one of the words you used was, or one of the phrases was, were they in the middle of a crime situation? They're not in the middle of a crime situation. This is the aftermath, a tragic aftermath of the crime. You can listen to one of the 911 calls. The car has already sped off. They're not in danger. The crime is completed.
How do you know that?
The crime is, they've left. The crime is completed at that point.
They sound like, I mean, that's just one factor, sir. I think you're reading it too narrowly.
But we can go back to Mr. Carlson, what that phrase you used that was in Mr. Carlson's book. And they are not in the midst of a crime. The crime is over at that point, Your Honor. If you'd like to limit me to 5 seconds, I'm happy to move on to a 403 analysis at this point, Your Honor.
Although I still maintain there's a confrontation clause issue with all 5 calls. I won't concede that.
Sure, and sir, I wouldn't expect you to do so either. And I will note that is your, certainly your position.
And Your Honor, I'd point out.
Let him finish and I'll let you argue now. Okay, all right. Okay, so still, I think it's or, and I think that is enough reading.
I
believe,
understand.
and I under 403 analysis, certainly, I'll note your objection that these calls are certainly more prejudicial than probative, but they are probative in this particular.
They are certainly more prejudicial than probative. Then they should be excluded. But
circumstance.
Okay, if I can discuss 403 just a little bit, Your Honor.
Sure.
Let's just look right at the 5th call. Okay, we can look at that one. There is nothing of probative value in the 5th call. All that you hear for over 5 minutes in the 5th call are people desperately urging,
telling the student to hang on. But it's
what's the probative value of that, Your Honor?
Well,
other than the tragedy of his death.
Well, we don't know that.
You listen to the call.
Yeah, I did.
I don't mean to ask you questions, but as long as we're having a dialogue.
I did, yes, sir.
I don't see any probative value of that, Your Honor, none. And when you look at that 5th call on top of the other 4, it's certainly cumulative. Why do you need all 5 of these 911 calls? Why isn't that cumulative?
Well, they also, in the 5th call, isn't Donovan Thomas nut? Isn't that his?
He's not, yes.
Well, then that's definitely one reason that they probably want to go ahead and get that.
Well,
in,
then,
that identifies him as nut. I mean, and then later potentially the decedent in this case.
Are they going to have no other evidence that identifies that man as nut?
I don't know, but
if they'd like to concede that they have no other evidence than the 5th call that identifies the decedent as Donovan Thomas as peanut or nut, then I can understand that. But it's going to come in over and over and over again that the decedent is Donovan Thomas. So even if you give that they say nut at some point in the 5th call, and honestly, I can't remember one way or the other.
It's near the end of.
But you've got 5 minutes of people desperately urging Mr. Thomas to hold on. It's highly prejudicial and it's cumulative. You've got the other 4 911 calls in there.
All right, I'll ask the state to distinguish that, but sir. Okay.
Do you really need all 5?
I'll ask them that within question.
Thank you, Your Honor. I appreciate you hearing this.
You're very welcome.
remember a few months ago when the judge says, don't do cumulative stuff. Don't waste the court's time.
All right, Ms. Lowe.
Thank you, Your Honor. Your Honor, the court's interpretation of the calls and the state's estimation is exactly correct. The each call is an effort to get assistance for a man who is dying. So the emergency remains ongoing, contrary to my colleague's distinction in terms of the crime itself. There's a person there who is still trying to hang on. And as far as the cumulative nature of the calls, Your Honor.
What's the difference between 1 and 5? Calls 1 and 5 seem to replicate the same kind of thing, but can you distinguish why the jury would need to hear both?
Yes, Your Honor. In 1, they're telling the 911 caller is giving sort of a description of where they are. We're right here in front of Castleberry. They're asking for aid.
Directions.
They're giving back, right. Okay. Just 1 second, Your Honor. In the first call, they say that they're at Northside and McDaniel, and they are describing that they're at a particular location. They are, of course, trying to get help, and they're just saying Northside and McDaniel. By the time you get down to the 5th call, since that's the 2 that we're distinguishing, we have the differences.
Again,
you have
I'm
the
playing
caller
this in
speaking to Mr.
1.5
Thomas.
speed.
You have the additional description. We're right here in front of Castleberry. They're naming particular landmarks that are relevant. We have multiple people who are around. We think it's as powerful what is not said as what is said. The fact that there are at least 5 calls that come in. The jury is going to hear from Detective Thorpe and others what they were and were not able to get from people on scene. We believe that the calls are necessary to paint the picture of exactly what is happening at that time for the jury. There are a number of people standing around. By the time you get to the end of the police sort of investigation on scene, you see that they come away with very few, if any, people who are willing or able to step forward and say what they saw and what happened. The state has a burden of proof. So to say that we don't need these calls because they are about, I guess, the same thing or they're doing the same thing is it's not taking into account the fact that we have to prove each of these things beyond a reasonable doubt. So every witness that we have, every call that we have, and the information that we're trying to put up is what.
Not if the only probative value of it is somebody saying the word "not" in the end of the call. You have 4 other 911 calls. Him, Mr. Donovan, is peanut. It can be well established without that.
The jury to be able to understand the facts of each of these situations as they occurred and to get the fullest picture possible of what happened at a particular scene. So our argument is that there is different information in each of the calls. There is a different person, there's a different descriptor, and there's no substantially more prejudicial impact that these calls can have than the fact that the man actually died. So for it to be excluded or for something to be excluded under the extreme remedy of 403 exclusion, Your Honor, it should have substantially a more prejudicial effect than probative. And the mere fact that Mr. Weinstein asserts that we don't need it is contrary to what I'm certain we'll hear in the end when the argument comes, the state hasn't met its burden. So every opportunity that we have to prove up relevant parts of this case, we're asking the court to allow us to do that.
All right, well, there comes a point where it is cumulative. I agree with you in this particular circumstance that call 1 does give directions, call 5 does give directions, but also gives more pertinent information about what's going on.
Yes, Your
and
Honor.
efforts for them to go ahead and get emergency services for Mr. Thomas.
And there were also 2 other people who were shot as well, Mr. Sanders and Mr. Hendrick,
Okay.
who are needing assistance as
All
well.
right.
And so if the court wants for me to go through 2, 3, and 4 as well.
I'm good.
I'm just going to respond briefly about call 5. The state gives away the reality of their position when the state says call 5 is powerful, which is another word for highly prejudicial. It is powerful because it is so unfairly prejudicial to the defendants in this case, Your Honor. There is no need whatsoever. It is duplicative of the other calls. It is unfairly prejudicial, and it is cumulative. There is no reason for call 5, Your Honor.
All right. Thank you, sir. I'm going to overrule your objection. I'm going to note your objections for purposes of the record. But assuming the state can lay the foundation, I'm going to admit the calls. Anybody else?
I have something. Good morning again, sir. Your Honor, there's a part where, and I don't know what he's saying, it's indecipherable to me, but it seems like.
Which call, sir, are you talking about? Are you talking about calls or are you talking about another issue?
Calls.
Okay, all right, okay. Which call to begin with?
Your Honor. That's in the first call, 2YA.
I'm being told by the Honorable.
To Yankee Alpha?
Yes.
Okay, all right, sir.
I can't make out the words.
In terms of what?
In terms of what is being said, it doesn't make a flowing, comprehensive communication. But I do hear Jackson. And there's a gentleman that the state is arguing is in a conspiracy with Mr. Williams, who is on trial with us, named last name Jackson. And Jackson Stillwell Jackson. And I'd like that to be removed. That you can.
I don't think so. I don't think that's going to get removed.
Okay, well, I'd like it to be removed under 403. I find it to be lacking in any probative value, and it's prejudicial because we're in an alleged.
But it's a potential one a excited utterance, and 2, it may be an identification of somebody. Now, whether or not the jury believes that, but the circumstances themselves lead it so that particular circumstance would, can be played.
If it's an identification, wouldn't that go to we need cross-examination?
No, because it's not, the primary purpose of the call is not, is a citizen-initiated call. It's not a police-initiated call.
Well, I don't think that's the distinction without a difference, because to me, an indiscernible just word Jackson or Steele or any name, Ruth, it's without context, it's just totally prejudicial. And then if the state wants to argue, hey, I'm not saying they would do this, but Ms. Love would do it, but no one else. But if they said, hey, that means it's an identification, we're going to come to you and ask for a mistrial, because that's not the evidence. And you're going to say, well, yeah, shouldn't have done that, but it's up to the jury. I'm trying to prevent that.
All right. Ms. Love, anything?
Judge, I'm not even sure what that was. Mr. Steele's interpretation of what excited utterances are made on the 911 call are of no consequence. They don't make it any less of an excited utterance. And his assertion that they might think that it's Jackson that's being said or whatever it is it still doesn't speak to the admissibility of these calls and their content.
All right. Mr. Steele, anything else, sir? Okay, all right. Okay. All right, I'm going to note your objection first, sir. Anybody else?
They didn't lay any foundation. They never do. Yeah, Judge Lenville will let anything in, and because that's what he does, because he has no spine. Somewhere along the line, he lost his faith in due process and is now just somebody sitting there acting judge. But in reality, he is as much part of the prosecution's team as Miss Love and Miss Hilton.
Okay, anything else before I call for jurors?
Your Honor, Mr. Steele is bringing over some exhibits or something he's asking us to listen to. We're kind of in the middle of doing 2 things, so I'd like if the court would allow us a moment to understand what he's saying and what he wants. It'd be great.
Okay, all right. Ms. Harvey, could you use your microphone? Thank you, sir.
think I did yesterday evening, but I do want to renew my motion to sever based upon prejudicial spillover, a 105 instruction with regard.
You did, and I forgot, sir, to again, acknowledge that you have once again, raised for purposes of your client severance based on the prejudicial spillover as you've argued, and you've also asked this court for a 105 limiting instruction, which
And you have been kind enough to give me a continuing objection.
I have, but
Okay, thank you.
that's fine. Okay.
Yeah. How is this not?
Yeah, unless you opt out, it will be, yes.
How is this not prejudicial against his client who has absolutely nothing to do? He's just there because he's mentioned once in one count. Why is he even there? He's actively in the risk of receiving life in prison for being mentioned once in one count.
All right, let's summon our jurors.
Oh, John, could you rule, because I objected last night, but to the CAD reports coming in, they would be 1TA, 1T.
1T Alpha through Bravo. No, actually, thank you for reminding me something. Do something. No, it's 1 Tango Alpha, 1 Tango Bravo, 1 Yankee Alpha, 62 India. I said Lima, but they're actually India Alpha, and 62 India Bravo. If the state can lay the foundation, everything but the narrative can be admitted. So I'm gonna grant it in part, and I'll rule it in part.
So, Your Honor, can I have, well, first of all, I'm reading that there's 2 additional exhibits. Am I wrong for the CAD report?
Yeah, the CAD reports in general, okay, are all going to be, assuming the state, Ms. Latner comes up here, lays the foundation, talks about the codes, she's the custodian, over your probable objection, I'm probably going to allow that. But I'm not going to allow the narrative, statements at the end.
Okay, so.
Without something, because the state hasn't told me any excited utterance as to whether or not they actually fall within there. So, and I can't hear them. So, which makes a difference in context for the court.
All right, and I understood. So can I just continue, if you don't mind, continue objection to it coming in at all?
Yes, you can have a continued objection.
Confrontation clause here.
Yes.
Okay.
Okay.
I appreciate it, sir.
All right.
I have, am I wrong? I have on this exhibit list here 2 other CAD reports that you didn't mention. You went up to 662.
No, there's additional demonstrative aids, Mr.
Okay.
Mr. Steele, and since I don't have any visibility on those, we'll take those up as needed.
All right. Okay. Thank you. I just want to continue objection.
All right, it's noted. Some of our jurors, please. Thank you.
Thank you.
All right, you're welcome.
I'm just getting my
All right. Reports to be, just listen to it, but I believe that Mr. Steele did ask Ms. Latner about that about the.
Here, I'll call it back. I've given all this to.
Need us to do
I
that.
don't know if needed.
All right. Okay. Thank you. I just want to continue objection.
All right, it's noted. Some of our jurors, please. Thank you.
Thank you.
All right, you're welcome.
I'm just getting my
All right.
Your Honor, we also have not had time to review whatever's on this thumb drive that Mr. Steele brought over a second ago. So if the court would permit us to do that.
At an appropriate time.
What's on that thumb drive is stuff that you gave them in discovery. So Mr. Steele can actually argue, well, they gave it to us. But he has ethics, so he actually brings it over.
Yes.
Yes, sure.
Well,
What is it,
So
Mr.
we
Steele?
have,
thank you for asking. It is the state put in without objection, part of police radio traffic from the 9th, 11th, 13 incident, Mr. Dotson or Mr. Bean. It's not complete. I'm completing it. Ms. Latner's here. I'll call it back. I've given all this. The state's given this to me. I don't understand how this is even taking any time. Ms. Latner's listened to it. Now the state has removed her, posted from it. I just need to get it in. Ms. Latner said it's exactly what it is. I'm going to ask her on a cross-examination, and it should not.
I believe that was asked when she was here last time.
Your Honor, for the stuff that has been admitted, we don't have any problem with. The point is that Mr. Steele constantly gives us stuff without giving us an opportunity to look at it, without a label on it.
Right,
So
that can be argued on both sides.
it
Ms. Love.
can,
So,
but we're just asking for an opportunity to look at it.
okay, all right, but if it purports to be, just listen to it. But I believe that Mr. Steele did ask Ms. Latner about that when about the instance of Mr. Bean.
Yeah.
So, and she's back on the stand to be testifying. So,
All we're doing is asking for a
Okay.
chance to look at it, to listen. to
yes, well, certainly.
Isn't it weird to be on that end, Miss Love? See how annoyed you got when you were presented with something that you didn't expect? You stock twat. Oh, I'm sorry. YouTube, I meant to say four-quad. It's the accent. It makes my words sound different sometimes, okay?
All right, ladies and gentlemen, please be seated. All jurors are present? All right, thank you. All right, ladies and gentlemen, jury, good morning.
Morning.
All right, okay, so, ladies and gentlemen, we're going to continue with the presentation of the state's case. Call your next witness.
Yes, Your Honor, the state calls Ms. Sharon Lattner to stand.
All right, summon Ms. Lattner, please. Ms. Lattner, if you once again approach the witness stand, and once you get there, if you turn to be sworn as a witness before you sit down.
Miss Lattner is not happy being back.
Sharon Latners, SharonLatners.
Good morning, Ms. Lattner, and welcome back. Good morning. Thank you, Ms. Lattner.
Good morning and welcome back. No answer. I like her. She knows this is bullshit. She knows this is absolute horse manure. I mean, she is the custodian of this. They could have done, yeah. If anybody is swaying the jury but just sitting there, it's her, because her entire demeanor towards the state is, why am I here? Why are we doing this? Leave me alone with my documents.
Now, I'm going to approach you, Ms. Lattner, with a number of categories. Your Honor, for the record, I am approaching Ms. Lattner with 1 Tango Alpha through Bravo, 1 Yankee Alpha through Bravo, 62 India Alpha through Bravo, 2 Yankee, and 2 Yankee Alpha through Echo, Your Honor. All right, sir.
And for you who don't know, I'm having a Finally Friday casual stream directly after this stream. So I will go on for 30, 40, 45 minutes with a recap of this thing. And then we will switch over to that other stream where I may or may not consume alcohol. I will bring up more garbage on Fannie Willis and Nathan Wade and stuff like that. So join me if you can. Well, I will redirect you over at least, but just so you're forewarned, it's going to be kind of a party, okay? It can be needed after all these shenanigans, okay? But let's continue with this recap.
Now, Ms. Lattner, once you're able to look through those, just look up at me and we will talk about it. Do you recognize those, Ms. Lattner?
I do.
And I'll start with the ones labeled 1 Tango Alpha and Bravo. How do you recognize those 2 documents?
They'll copy Atlanta 911 CAD report incident.
And are they a fair and accurate depiction of the CAD reports for that incident?
Yes.
And then I'm gonna turn to the exhibits marked 1 Yankee Alpha and 1 Yankee Bravo. Should be the 3rd and 6th document for you. Do those documents, do you recognize them?
I do.
And are they a fair and accurate depiction?
Yes.
I'm gonna turn to the 2 exhibits, 62 India Alpha and Bravo. Do you recognize those documents, Ms. Lattner?
Yes.
And are they a fair and accurate depiction of the CAD reports related to that date?
Yes.
And finally, we have a document that's 2 Yankee, and then there should be a CD that's 2 Yankee Alpha. Do you see those, Ms. Lattner?
Yes, sir.
And do you recognize them?
I do.
And are they a fair and accurate depiction of the incident on that day?
Yes.
Your Honor, at this time, state tenders and evidence, states exhibits 1 Tango Alpha and Bravo, 1 Yankee Alpha and Bravo, 62 India Alpha and Bravo, as well as 2 Yankee and 2 Yankee Alpha at this time.
The numbering and lettering system, that is Judge Glanville's military history. That is, when you say the letter E, you say echo to enhance. You're actually saying E because certain accents, certain letters sound differently. So they attach words to it, so it's no misunderstanding. So that is what he's using.
Let me just do it this way. Any objection or any further objections to statements 1, Tango Alpha Bravo, that otherwise has not been noted.
Not otherwise.
Okay, I'll admit it subject to early rulings of the court. What about 1 Yankee Alpha, 62 India Alpha, or 62 India Bravo?
At the same answer.
All right, then the court will admit those over objection, subject to the court's earlier ruling.
Thank you, Your Honor. And I'm going to, in regards to 2 Yankee Alpha, this is a disk, but it also contains, for the record, I'm also kindred 2 Yankee subsection Alpha through Echo, so Alpha Bravo Charlie Delta.
Just a reminder to hit that thumbs up here. There is currently 140 watching and only 80 thumbs up. We need to get to at least 100 thumbs up. Okay, folks? The YouTube algorithm, the more you speak in chat, the more thumbs up and stuff like that, then they keep promoting my channel to more people. So please do.
Any further, any objections, I should say, to states 2 Yankee Alpha through Echo?
I have the same objection.
Okay, all right. The prior objections have been noted. The court will admit it over the over objection. And maybe probably should you see fit, subject to the court's earlier rulings.
Thank you, Your Honor. Now, Ms. Ivers, let's start documents. Let's start with 1 Tango Alpha. Can you tell jury what happened, or what is 1 Tango Alpha? What is that?
It's an incident from January 6, 2015.
And how did that incident come about? Your Honor.
Objections? I'm sorry. Objection. Basis?
Confrontation clause, hearsay.
Let me take away the question.
Yeah, this prosecutor assistant.
I'm over the objection.
Ms. Ivers, you may answer, you may have forgotten the question. What is the nature of that call?
Unit 1111 pulled out on this call.
And what kind of call did they pull out?
Fight in progress,
What is the code for a fight in progress?
29.
And Your Honor, the state's also going to publish State's Exhibit 1 Tango Alpha. And Ms. Ivers, when you say that unit pulled out, what do you mean by that?
He advised his dispatch to hold him out at that location. Was a fight in progress.
And this was on January 6, 2015?
Yes.
Now, what was the location that the officer pulled out to?
2517 Donnelly Harwell Parkway, Northwest Atlanta.
And Ms. Ladders, what zone and beat is that 2517 Donnelly Harwell?
Zone 1, 109 speed.
And what time, well, let me ask you this, Ms. Ladders. Is this a 911 call or officer generated CAD?
Officer generated CAD.
And what was the unit number of the officer who pulled out?
Unit 1111.
Do you know who that is, Ms. Ladders?
No, I don't.
Now, what time did this officer self-initiate this call?
02/28/42 a.m. hours.
And is the dispatch time the same time as you started the call on CAD report?
Yes.
Is that because it's self-initiated?
Yes.
And Ms. Ladders, what time did that officer clear that call?
03:55:22 a.m. hours.
And Ms. Ladders, for this type of call for a 29 fight progress, what type of priority does that call have?
I need to give some background. Donovan Thomas was shot in a barbershop in 2015. And the basis of why this is in this trial is that the prosecution alleges that Mr. Williams rented a car that was used in this drive-by. That's it. And we already know that Mr. Williams rented cars for people on a whim. If it's actually that car. But we'll have to wait and see. This is the next phase of the prosecution's case is the ending of Donovan Thomas. So I assume that for the next month, we will be hearing a lot about this particular case. And yeah. Yeah, let's just continue.
A prior to 3 calls, 20 minutes response time.
Ms. Ladders, I'm going to turn to 1 Tango Bravo. Now, Ms. Ladders, is 1 Tango Bravo, is this the same date,
Yes.
and I'm gonna publish one Tango Bravo. What was the call type and description for this call, Ms. Lyles?
2969, which is the domestic fight and weapon involved.
And what is the location for this cab?
2517 Donnelly Harwell Parkway, Northwest.
And is that the same location as the cab report we just discussed?
Yes.
What time was, and let me ask you this before I ask that, was this a officer generated or 911 call?
911 call.
What time was the 911 call made?
0229 15 a.m.
When were officers dispatched after that 911 call?
Dispatch at 0231 57 a.m.
And what time does that indicate that that call was cleared?
0352 44 a.m.
Now, Ms. Lyles, if you turn back to one Tango Alpha that we just discussed, how close in time is this incident cleared in relation to the one we just discussed at the start?
What time it cleared?
Yes, ma'am.
Well, one cleared at 0352, one cleared at 0355, 3 minutes apart.
And Ms. Lyles, if you look at these cab reports, do they reference one another as in related calls, or do they not?
Yes, they do.
And can you explain how cab reports, how it comes to be that they're related, or how is that, what determines if something is related?
But they have the same address. So the dispatch automated knows that they coincide together. They related to each other. So to keep a record of the incident, she just relate 0299 to 0294 and 0294 to 0299, so they can have a record of it.
And you, Ms. Lyles, do you know, is it that location, 2517 Donnelly Hollowell, is that a residence or business, do you know?
I don't know.
And where do they reference one another in cab reports?
When you come down, it says police. In the middle of the cab, it says police, and it has 15006 0294. As police 15006 0299.
Now, Ms. Lyles, I'm going to turn to State's Exhibit 1 Yankee Alpha. What is the date for 1 Yankee Alpha, Ms. Lyles?
January 8th, 2015.
What was the call type and description for that case?
It was 25 shots fired.
What type of priority does a shot fired have within APD?
On here it shows prior to three, with 20 minutes response.
What is the location for the shot fired call?
988 Confederate Court, Southeast Atlanta.
Ms. Lyles, do you know what type, if it's a residence or business at 988 Confederate Court?
I don't know.
And was this call, Ms. Lyles, was it a 911 call or self-initiated?
Self-initiated.
What was the time that this call was self-initiated?
0038:30 a.m. hours, which is 12:38 a.m. hours.
And what time was this call cleared, Ms. Lyles?
It shows 02:25:33 a.m. hours.
And Ms. Lyles, what is the 20-minute response time? What does that mean?
It means that the dispatcher have 20 minutes to get the dispatch, to get that call out to a unit. But since this was self-initiated, the system put this priority times on itself.
Thank you, Ms. Lyles. What determines that in terms of how the priority is set?
They were set by APD head commanders, so they prioritize each call by call type.
Thank you, Ms. Lyles. Now, do you see the two cab reports that start with 6288 yet?
Yes,
I'm gonna start with 6288 Alpha. You see that one, Ms. Lyles?
yes.
What is the date on that incident?
January 8th, 2015.
What is the call type and description?
Shot fired. 25, sorry.
No, you're fine, Ms. Lyles. What was the location for the shot fired?
675 Metropolitan Park, Southwest Atlanta.
Was this a 911 call or was this officer generated?
911 call.
What time did this 911 call come in?
23:13:02 p.m. hours, which is 11:13:02 p.m. hours.
What time were officers dispatched or arrived in response to that call?
23:14:36 p.m. hours.
Now, was this incident, does it have any related cases that are connected with it?
Yes, it's related to CAD 150083130.
What were the unit numbers of the officers who responded to 675 Metropolitan Parkway?
Unit 1307.
Now, Ms. Lyles, turning to 62 India Bravo, is that the cab report that was related to what we just discussed?
Yes,
Is it the same date?
yes.
What was the location for that cab report?
1064 Metropolitan Parkway, Southwest Atlanta.
What was the call type for, what came in, or what type of call they responded to?
It was a self-initiated call, reckless driver, which is a 72.
What zone and beat was that?
Zone 3, 302B.
Now, what time is that call cleared?
It was cleared at 01:10:50 a.m. hours.
And what was the priority response time for the 72?
20 minutes.
Is that the same response time for the cab report we just discussed and shots fired?
No,
What was that response time?
10 minutes.
Now, Ms. Lyles, I'm going to turn to what's labeled as State's Exhibit 1 Yankee Bravo. What was the date and time that this call, this cat report pertains to?
January the 9th, 2015,
What was the call type that generated this cat?
25 shots fired.
What was the location for this cat report?
Spring Street, Northwest Ivan Allen, Junior Boulevard, Northwest Atlanta.
Now, Ms. Landers, what was the zone you beat for that location?
Zone 5 is 508 beat.
What time was the call received?
Call came in at 10:58, 37 p.m. hours.
How quickly did officers get dispatched?
They got dispatched at 23:04, 27 p.m. hours.
And what time was the call cleared?
Cleared at 23:13, 20 p.m. hours.
What was the priority response to this call?
10 minutes.
Now, Ms. Landers, I'm going to turn your attention to what's labeled as 2 Yankees, this cat report. Can you describe for jury what was the day of this cat report?
January 10th, 2015.
What is the call type and description?
Call type of says 48 person dead, but the call came in as a 50 person shot.
Now, can you explain to the jury, when you said, can you elaborate on that, what the call come in as?
Call came in as a 50 person shot. But once they finished investigating the call, the officer changed the signal to a person dead, 48.
What was the priority response on this call?
A priority 2.
And would the priority be, would it be set by the person shot at 50, or would it be set by the 48 person dead?
Person shot.
Now, Ms. Landers, what was the address and location for this?
330 McDaniel Street, Southwest Atlanta.
What is the APD zone and beat?
Zone 5, 507 speed.
Now, Ms. Landers, when you look at units that responded, how many units responded to this call? If you have the ballpark, that's all I can say.
I'm gonna say up to 15 units or more.
And was this generated from a 911 call or self-initiated by an officer?
911 call.
What time did the 911 call was placed?
Call came in at 07:22, 20 p.m. hours.
What time were officers dispatched?
I'm sorry, correct myself. Call came in at 19:22.
Is that 7:22?
It's 22:20 p.m. Officer dispatched at 7:22, 54 p.m. hours.
When does it state that officers arrived?
They arrived at 7:25, 13 p.m. hours.
Now, after arriving at 7:25, what time was the call cleared?
It would clear up the next day at 12:30, 20 a.m. hours.
Now, Ms. Landers, when we had, the only thing out there that's with you, you see that CD disc that's not a cat report?
Yes,
Is that pertaining to this cat report that we just discussed?
yes.
And what is contained on what's marked as 2 Yankee Alpha through Echo?
5 911 calls.
Your Honor, at this time, the state is going to play what's marked as 2 Yankee Alpha.
All right.
Yes, that police over here on the north side of McDaniel.
North side of McDaniel, why did you say?
Yeah, at Harold Liberty Barber Shop. Somebody don't got shot.
Confident was gonna hang up. One mama said do not hang up. Don't hang up, sir, okay? Hello, 5, what's the address of the emergency? Hello, Grady EMS.
Oh, no.
Grady, call advised, Northside Drive in McDaniel, person shot, male shot outside of the barber shop. Okay, already, go ahead and start firing PDM 785. Thank you. Hello?
Lock the door. I mean, 911, man. I gotta be home. First of all, I know what that is, bro. Get down, man. You don't lock the door, man? You don't lock the door?
Hello, sir?
ain't nobody coming in. Get the fuck out of my house, man. Y'all niggas sit your ass down, you gonna be in hell now. Come here, man. It's like this one to do.
Yeah. You took the words out of my mouth, Lucentil. Wait, this call is evidence. It's just beeping and feedback. Yeah. This is cumulative. It's only there to bolster the other. Oh, look. There are 5 911 calls. Yeah, but you only... I mean, to prove the incident, you need 1. Yeah, so
Approaching you, sliders,
skipping ahead a bit.
for 2 Yankee Foxtrot 1 through 7. Now, Ms. Ladders, I'm gonna flip through these. So I'm showing you what's first been marked as 2 Yankee Foxtrot 1.
Have you shown those to councils?
Your Honor, I can. They have smaller copies of
Why don't
these.
you make sure you show those to me?
Yes, Your Honor. If any council wants to see, they are identical to what's been provided. There's no change.
All right, sir. They have the changes.
Oh, yes, there is, correct. Yes, so there's.
Why
Did
don't
I
you
see
show
the
the
final
final,
version?
just
Yes,
show them.
yeah.
This assistant district attorney, he tries. And this is the demonstrative that is trying to get entered. Skipping ahead a bit.
Thank you.
And they are having a sidebar. Which brings us to sidebar counter 181. Yeah, there are some big issues about that sidebar. And thank you, Betty Winder, for a $10 super chat. Thank you so much. And it is a pair saying thank you. Thank you. Thank you so much. These supports, the occasional super chat and membership, that is what keeps this channel afloat. And it is your first super on a live stream. I'm honored. Thank you so much, Betty. I'm very honored for me being your first super on a live stream. Thank you so much. Woo! Do I have something here that... I know other channels have these bells and whistles. The closest I have is this. What can I say? Should I start doing those bells and whistles thingy? I mean, I have this bell. Ta-da! I'm not high tech. People have soundboards and everything. I try to look up a soundboard and I'm staring at it until I'm cross-eyed. I can't make back and forth on it. I will get my nephew here to try to train me on these things because I'm a pen and paper kind of guy. Thank you again. Thank you again, Betty. The wheel of regrets is enough. Now, the casual stream later is not a wheel of regret thing. It is me because on my birthday a couple of weeks ago, or over a week ago, I got handed a couple of bottles of bubbly wine. So I thought I would do this casual stream is me taking the piss out of Fannie Willis, reading things about her making $2.5 million disappeared that should have gone to a youth center, to grape kits handling and stuff like that. But under her direction, it just went away in travel expenses and stuff. So that will be the casual stream. Me having some bubbly and taking the piss out of Fannie Willis.
Foxtrot 7. So
That was a
Miss
long ass sidebar.
does 2 Yankee Foxtrot 7, will it aid your testimony in what we have been discussing with this jury?
Yes.
And is the information contained on 2 Foxtrot 7 the information that we have discussed in the exhibits we've admitted today?
Yes.
And is it a fair and accurate depiction of the information that is on this exhibit with what is contained in the accompanying report?
Yes.
Your Honor, at this time, the state tenders into evidence for demonstrative purposes 2 Yankee Foxtrot 7. State's exhibit.
Any further objection to states 2 Yankee Foxtrot 7?
None of them have already been
Okay,
stated, Your Honor.
all right. Early objection's been noted. I'll admit 2 Yankee Foxtrot 7 over objection. It may be shown as a demonstrative exhibit as you see fit.
Thank you, Your Honor. Your Honor, with the court's permission to make it so everyone can see, I'm going to put this easel in this part of the courtroom. If that's all right.
Councilors, you may relocate yourselves
Thank you, Your Honor.
so everybody can see. Do you have the ability to put it on the?
Yes, Your
Can
Honor.
you do that so others who are not going to relocate can do that? Can see, please.
Your right shoulder.
Oh, stop doing that.
Now, Ms. Ladner, starting with.
The wheel of...
Can you explain for the jury what is depicted starting with the, on this demonstrative January 6th?
Want me to do what now?
Can you, so I will, here, I'll,
So he made a demonstrative. Congratulations. At least he doesn't do as Miss Love did with the pen on the board thing, which looked absolutely moronic. This is comprehensible, at least. Now, is it correct? I have no idea, but it looks good.
I'll help Ms. Ladner with this one. So starting here is, what was the date and time of this incident report that we discussed?
January 6, 2015.
And does this correspond with 1 Tango Alpha that we discussed?
Yes.
What is the last 3 of the APB case number?
294.
And what was the location and call time?
Objection has been answered.
Overruled.
What was the location, Ms. Ladner, for this January 6th incident?
2517 Donnelly Hardware Parkway, Northwest.
And what was the call type and description?
Objection has been answered.
I'll sustain the objection.
Ms. Ladner?
The sitting is 29. Description is fight in progress.
Ms. Ladner, after we discussed 1 Tango Alpha, you recall talking about 1 Tango Bravo?
Yes.
Is where this pointer, which is the second demonstrative with gray for the record, is this what we had discussed in 1 Tango Bravo?
Yes.
What was the last 3 of this ABD case number?
094. No, I'm sorry, 0. Last 3 is
Yes, ma'am.
299.
And is this the same location as the first call that started at 2:28 a.m.?
Yes.
Objection has been answered.
I sustain the objection.
Now, Ms. Ladner's turning to this third icon that's depicted in blue, and it's January 8th at 12:38 a.m. Do you see that, Ms. Ladner?
Yes.
What is the last three for this January 8th, 12:38 a.m. call?
094.
And was that a shots fired call?
Correct.
And does that correspond with what we had discussed as one Yankee Alpha?
Yes.
Objection asked and answered.
Oh, objection, sir.
Now, Ms. Ladner's turning to the fourth icon, which is gray, and it's January 8th, 11:13 p.m. You see this, Ms. Ladner?
Yes.
Now, what is the last three of this APB case number?
128.
And does this correspond with what we talked about in 62 India Alpha?
Yes.
And was this a shots fired call?
Yes.
Objection asked and answered.
I'll rule the objection, sir.
Now, Ms. Ladner's turning to the fifth icon, which is January 8th, 2 minutes later at 11:15 p.m. Do you see that, Ms. Ladner?
Yes.
Is this the same, or what is the last three of this APB case number?
130.
And was this correspond with what we talked about at 62? India Bravo?
Yes.
Oh,
And,
Jesus Christ. Sorry, folks. Boomer moment. I was just saying, why are there empty slots in this graph thingy? Either he is going to add things, or this is a standard issue that he just filled in and forgot to put the empty slots out. I don't know.
Discussing, is this the one that pertains to came in as a 72 record striker? Objection asked and answered.
Oh, sir.
You didn't pull it out as a 72.
Now, Ms. Ladner's turning to the sixth icon, which is January 9th, 10:58 p.m. with gray background.
Oh, hi,
Yes.
Linda.
What is
You're
the last
pads
three of this
nowadays.
APB case?
Okay. good to know.
290.
And what is the location and call type for this January 9th, 10:58? Objection asked and answered.
Oh, sir.
Shots fired, Spring Street at Ivan Allen Jr. Boulevard.
And it looks like, Ms. Ladner, would you agree with me? It looks like there's a scribner's error above January 9th.
Hello, Wim. This
That
is
is the same as
live.
what's depicted as January 6th.
Yes.
But on the January 9th, 10:58 p.m. incident, that is what we talked about as one Yankee Bravo. What was the location and call type for that? Objection asked and answered.
Oh, rule, sir.
Shot fired, Spring Street and Ivan Allen.
And Ms. Ladner's finally with what's depicted in red as January 10th at 7:22 p.m. Do you see that, Ms. Ladner?
Yes.
What was the location and call type for this?
Location is 330 McDaniel Street Southwest. Came in as a person shot.
And what is the
It
last
is
three
the
of the
same
APB case?
thing
106.
over and over again.
Do these incidents we just talked about on this demonstrative 2 Yankee Foxtrot 7, is that encompass the January 6th through 10th incidents we discussed?
Yes.
Thank you, Ms. Ladner. Your Honor, I'm going to publish what's been marked as State's Exhibit 2 Yankee Echo.
All right, sir. No, I don't.
This hasn't been played?
No, this is the last thing, the last thing. All right, I'm gonna hold the objection.
What was that, Mr. Steele?
Can you take that down, Mr. Atkins? Because, yeah, they, folks out here can't see it.
I mean, I thought we only listened to 2 calls, but apparently they're making short successions of all the calls. They sound the same to me. This last one is apparently where Mr. Donovan Thomas is heard on the tape.
Your Honor, resume publishing State's Exhibit 2 Yankee Echo.
Okay.
Yeah, you're
What's the address of the emergency? I got you. You got him there. Come on, baby. Stay there. Stay there. Stay there. Keep looking at me. Keep looking at me. Look at me. Stay there. You all right? You all right? You ain't. You ain't. You ain't. You ain't. Keep fighting. Do it, Chief. Keep fighting, dog.
right. You all right. You all right. You got something to live for. Bro, you all right, bro? You got something to live for. You got a want to live. You got a want to live. You got a want to live. Okay? You all right? Where you hit it? Where you hit it? Where you hit it? Huh? Shut up. Shut up. Fuck. Here now. Yeah. Fight, bro. You all right, bro? Fight, baby. You okay, bro? Come on, bro. You probably right here with you, bro. You okay, bro? I don't know. You okay, bro? 49, bro. You okay, bro? Okay. Got a man out here, too. You right here for the captain there. I'm all right, bro. Come on. Die with you. Can you hear me? Can you hear me? Hold me on. Come on. You all right? Come on and fight. You okay, bro? Come on, fight. You okay, bro? Bro, you okay, bro? I'll be out, bro. Where you go? You okay? Go fight that. Fight. Okay, fight. Huh? God is able. You still there? God is able. Holy shit, the fucking able. God is able, Black. God is able. Okay? You hear me? Huh? Do you hear me? Please, somebody, please. Huh? You hear me? Get some towels. That's what we're trying to find out. You have to get the land in the back there or something. Where you hear that? Hey, keep breathing. You understand? Keep your breath. Where you hit that? Where you hit it?
Yeah, CC22 still don't understand what playing this is supposed to do except grab sympathy for the viewers. That is the sole reason for this to be there. It's not needed. They have 4 other 911 calls and people testifying. They don't need it. This is purely for sympathy, to make the jurors so angry that they will try to convict these guys. That's the sole reason. The judge saying excited utterance, bullshit. Complete and utter bullshit. He knows it. I bet you he knows it. But he is so invested in convicting these guys, so he will let more or less everything in unless he absolutely knows it will be an unforced error. And I do believe there are dozens of appellate issues that are unforced errors already in this trial.
Where you hit it? Where you hit? That's what I'm trying to find out. Where you hit? Baby, where you hit? Oh my God, go. Yeah. What's the other 2 people shot? Are they working in? One right now. I'm a plate here. APD. Right now. You get a long farm without the back of the truck.
Thank you, Ms. Ladder. Not the first one to say.
Ladies and gentlemen, before we begin cross-examination, I want to take a comfort break, maybe about 10 minutes. Okay, all right.
Yeah. Yeah,
We're
this
gonna recess 10
custodian
minutes. All rise.
of the records, that was her sole reason for being there, to get these in. Then they have a break. Long ass break. And now cross-examination.
Mr. Weinstein?
I have no problem.
All right. Mr. Steele? All right.
Thank you, Ms. Latner, for all your effort and support.
You're welcome, sir.
I'd like to show you what I've marked a thumb drive as Mr. Williams number 202. And Your Honor, it's A, B, C, D. 203,
So you say it's Jeffrey Williams 202?
yes, and then the whole thing's 202, but then it's A, B, C, D. So it's 202A, 202B.
Alpha through what? Through what?
David, Delta. And then 203, Jeffrey Williams Exhibit 203. And that will be A and B.
It doesn't.
Elisa Barry, Alpha.
It doesn't connect to
Alpha,
Shannon
Bravo.
Steele. Well,
Terrible.
the connection here. The connection here is the prosecution alleges that the car used in this drive-by was rented by Mr. Williams, but that's about it. That's it. And he rented cars for friends and stuff all the time, without, oh, can you get me a car? Okay, I'll rent one for you. Now, is that a stupid move? Yeah, it is. It's really dumb. But here we are. It doesn't prove connection that he in any way facilitated the drive-by, because the persons doing the drive-by would have gotten another car. So.
And that will be A and B. Elisa Barry, Alpha, Beta, Alpha, Bravo.
Terrible. You
Bravo.
keep mixing up. Look, there's the Greek alphabet. We're not going to talk about the Greek alphabet. This is the military alphabet, okay? And then there's your lovely wife and all the other things that you wish to do, okay? So
It's my family alpha.
let's just
My
go ahead.
children, my
Let's
wife.
just go ahead. Let's just go. It's just simpler for the court and keeping track of it. So alpha through.
Hey,
through delta.
Code Hater, you
And
made
203
it!
is what?
Yay!
203, Your Honor.
Okay, and then what?
A, B, and so it's 203, and then there's a subset A and B. So 203A, 203B, and then 204. And then there's one subset 204A.
Hi, Tess. No, my significant other will not be joining me in my USA trip. She will be having a Mediterranean cruise with her boys, with her sons. So, no, she won't be joining. She, for some reason, she's a bit of a leftist. She doesn't like the United States. So we are really not on par on that issue. I love the United States. I think it's amazing. But she is a bit of a leftist. Let's just leave it at that. So yeah, so no, she will be taking a cruise in the Mediterranean instead.
For A and B?
No, just A, Your Honor.
Okay, all right. Let me see if I.
Wait a minute, this is-
It's Jeffrey Williams 202 Alpha through Delta, Jeffrey Williams 202 through Alpha and Bravo, and Jeffrey Williams 204 Alpha.
That's true.
Okay.
Yes. Yeah, I
Okay.
think that's what the court said. Yes, so it's
So there's
202.
a 202, a 203, and a 204, and then the numerics
That's
that
right. Yes, that's
that
true.
are sought to be admitted.
May I approach?
Okay, all right.
Latner, may I approach you?
If I have a choice. You fine, sir.
I'm going to show you, put a, so just stick around. I'm going to show you what I've marked, what I just announced. On a thumb drive, and it's Mr. Williams exhibit number 202, and then the subparts A through D, then 203, AB, and then 4A. Have you had an opportunity to review that thumb drive, or the contents of the thumb drive, I should say?
Yes, sir.
And does that contents of the thumb drive, do you recognize what it is?
Yes.
And does it accurately depict the radio traffic from September 11th, 2013?
Yes.
And is it, to your knowledge, any changes, modifications, alterations to that radio traffic?
No.
Your Honor, I will move for the admission of Mr. Williams, exhibit number 202, and then the subsets that we announced, A, B, C, D, 203, subset A, B, and then 204, which is a subset A. So it's like the court board said, you have all three, 202, 203, 204, and then those subsets.
Stating objection to Jeffrey Williams, 202 or 202 Alpha, Bravo, Charlie, and Delta?
No, Your Honor.
All right, what about Jeffrey Williams, 203 Alpha and Bravo?
No, Your Honor.
And Jeffrey Williams, 204 Alpha, 204 and 204 Alpha?
No, Your Honor.
All right, they're admitted and may be published as you see fit.
And Ms. Latner, it's just a question because you came and discussed part of that radio traffic previously in your testimony. Is that fair to say?
Yes.
But I just wanted to put in the entire radio traffic. Is that now the entire radio traffic as far as that incident?
Objection, Your Honor, just to commentary.
Okay, I'll sustain the objection.
Is that?
Yeah, this is what the prosecution did during the laundromat incident. They only put in some things, and then Mr. Steele and the defense entered the radio traffic that showed not only were there surveillance camera, which the prosecution denied was, and claimed no cop saw a surveillance video. In radio traffic, in that laundromat incident, not only were there a surveillance camera, they were radio traffic with cops saying, we are waiting for the owner of the laundromat so we can access the surveillance camera. And radio traffic about cops is now watching the surveillance video. So the prosecution lied to the court, saying there were no such thing.
What is that the radio traffic in its entirety?
Yes.
Okay. Your Honor, I don't have any other questions. Thank you.
Thank you,
Ms.
sir.
Latner, thank you.
All right, any further defense examination?
Yeah, this is now, because last time there were they didn't really reveal that they had access to all the radio traffic. Now they are warning the prosecution, hey, we have all the radio traffic. Don't try anything like last time. Which is going to deaf ears because the prosecution will try to do it anyway.
Ms. Latner, good morning.
Good morning.
Ms. Latner, you are the custodian of 911 calls and CAD records for this county, is that correct?
City of Atlanta.
City of Atlanta, correct. And you've testified in various counties and jurisdictions where City of Atlanta has brought themselves over into perhaps DeKalb County, correct?
Correct.
All right. So as the custodian for the City of Atlanta, obviously, we have listened to some 911 calls, correct?
Correct.
All right. You certainly were not present at any of these locations, correct?
Correct.
You don't know the circumstances involving any of these 911 calls that we've heard, correct?
Correct.
You don't know any stories from one side or the other in terms of how any of these events occurred, correct?
Correct.
You have basically given us a rundown of these calls, correct?
Correct.
In the calls that we heard today, you did not hear any calls in these particular ones that have been played before you this morning of any YSL. You did not hear that word or that phrase in any of those calls, correct?
Correct.
We did not hear any particular person that's sitting in this courtroom. We did not hear their name on any of those calls that we've heard that were played this morning, correct?
Correct.
Your Honor, it's not a question.
I'll sustain the objection.
But you did hear the calls yourself, correct?
Correct.
That's all I have. Thank you.
All right, sir, thank you. Any further examiners, defense examiners? Any redirect?
No, Your Honor.
All right. May Ms. Latner's be permanently and temporarily excused as a witness. All right, Ms. Latners, we'll see you when we see you, okay? We'll give you enough time to rejoin us when that time comes. Let's enjoy your weekend, madam.
Thank you.
Okay, thank you.
I don't. If Miss Latners
Yes,
chooses
you may.
to go up to the prosecution and punch them, I would say that's justifiable. I would say that's completely justifiable. See here, and look at that. They have a sidebar, which brings us to sidebar counter 182. Let's skip ahead a bit. Diana Davis, why do they need to call her again? Because she is the custodian of the records. And so every time the state wants to bring in 911 calls or CAD reports, they will bring her back to testify, yes, these are the actual reports and the 911 calls.
Okay, ladies and gentlemen, I have good news and I have kind of bad news for you, okay? Which one do you want to hear first? Okay, you're gonna have to come in on Monday, all right? That's the bad news, all right? The good news is we're finished for today. All right, so we're going.
Yeah. Next week was supposed to be the entire week off, but the judge decided no, Monday is trial day. And yeah, so Monday I will again do some kind of recap on this. But the rest of the week next week will be updates on the Delphi case, possible the Adelson case. I will hopefully have news about the Shane Kendall case, the wrongful death suit that occurred in the Fulton County Jail. I will do updates on that. I have contact with his lawyer, and with some luck, I will do a stream with his lawyer next week, if we find the correct timing and everything. So yeah, so that is some of the things next week, except Monday. But let's get through this final part here.
No, here, I'm gonna tell you, and let me fill in the rest of this. Paul Harvey says the rest of the story. Okay, yes, originally we were going to be off all next week. My other business that I thought I was gonna be taking up is I'm not taking up on Monday. So we're gonna reclaim a little time and go ahead and have a full day of work on Monday. That's now.
Yeah. The reason why he now has to make these weeks here and there is because he believed this trial would be over. So he has other trial scheduled, other hearings scheduled for this courtroom. This will prolong this trial even more, because once in a while he have to take a week of this trial for other cases. I told you, we are going to be watching this trial for the next year, if not longer.
The rest of the week is still the rest of the week. You're going to get the Tuesday through Friday, through the Memorial Day Monday will be off. Okay. That just happened. I just found out about today. So I shared that with counsel as well. So we're going to come in on Monday, and that's the only day we're going to work. Who you met earlier is a person that submits that time. So we go through him. Inquiry of me. Consider what's you're sitting back.
Okay, let's see what the final minutes is here. And then I will be sending you over to my casual stream, where we will be taking the piss out of Fannie Willis. How she managed to lose $2.5
Okay,
million
ladies and gentlemen, our jury has left
of
us.
federal funds.
Okay, please be seated. Ms. Hilton, you wish to correct an exhibit? That's been brought to my attention?
I did, but I had to do it in front of the jury, but I'll do it now and then do it in front of the jury on Monday. Stacy 135 Echo Charlie is now.
You all right?
Stacy
Okay.
135 Echo Charlie.
Which
were the excerpted
Yes,
phone
there might
records
be
of phone number
visit from
1990.
Santa Laws.
Okay.
will be changed to State's Exhibit 135 Echo Delta. And that's it, Your Honor.
Is that because there's two exhibits that are,
135 Echo Charlie.
and that was the one is the Sprint and one is the Cricket, correct?
135 Echo Charlie may be the,
What was it? I need to know what it was.
yes,
And
so-
what it's going to.
so 135 Echo Charlie was the,
Yeah, I know. I skipped that bit. The jurors complained about not. They are supposed to get paid after 2 weeks. They get, but somehow the court system forked up, and they are waiting for, I don't know, $200 for a number of days, $250, something like that.
excerpt that we printed out regarding the phone number 1990.
Okay.
And now there were duplicate 135 Echo Charlie. All of this pertains to the phone record ending in 1990.
Okay.
Thank you, Your Honor.
All right. And just, you can, we'll make that correction. All right.
Thank you.
Okay. Any other ministerial inquiry with me, councils? Let's cover who's going to be called on Monday.
Judge, we're going to call the witnesses that we're going to call today, which includes Officer Corey Clinton Hayes, sorry.
What's his name? I'm sorry again.
Hayes, Hayes.
Officer Hayes.
Yes.
Hay.
Yes.
Oh, no, E. Okay. All right. Okay.
We will also be calling Lieutenant Volley, Volley.
First name Anthony, Your Honor.
Okay.
And Your Honor, if the court would permit us to apprise the court of the remaining witnesses, as we had not anticipated calling witnesses on Monday, we just want to line those up, and we can let the court know by 2 o'clock at the latest. But I think we'll be able to know as soon as we get back to the street exactly who the other ones will be. But we'll have a full day on Monday, so we need to fill up that day.
All right. Have you otherwise
You need
turned
to-
over
you
or,
need to fill up that day, because you haven't prolonged every damn witness you ever had on the stand. Yeah.
notified your colleagues across the bar as to what exhibits that you are planning on introducing? Any video, audio?
For the ones that for the first two witnesses that we were going to do today, we had. For the ones that we will now call on Monday, we will. We have not, because, okay, wait a minute, Ms. Hilton is correcting me. She's gonna stand up.
Your Honor, last week we sent a first set of exhibits that we planned on using the week after next. And so we'll just need, so they should have, ideally those witnesses will be who we'll start with on Monday. So they should have at least that first additional set of exhibits. And when I say set of exhibits, the pool that we're going to pull from, which are the exhibits. And then we'll be supplementing that, Your Honor. Yes, sir.
Could you either resend that or we get so many emails. So could you just identify when that was sent so I know which exhibit you're talking about?
Yes, it was sent last Friday, probably around 5:00 p.m. By me. And it was a Dropbox link. And the password was in the link.
Okay, thank you.
You're welcome.
Okay, anything else, councils? All right, then we'll see you all Monday morning at 9 o'clock.
All right, that was this week. This week, it's done. Absolute horseshit, absolute irrelevance, absolute cluster F. As every week. But a few highlights. Mr. Steele ruined the prosecution's timeline regarding the bus shooting completely. Completely. The judge ruled wrongly on the completeness clause and the confrontation clause. Also a weekly occurrence, in my opinion. Let's see here. Finally, Friday casual stream will start in about 20 minutes. I need to visit the big boys room, so I will not make it earlier. So I will see you over there in 20 minutes. Go grab a drink of choice. There can be snark. There will be snark. may be an appearance of Santa Claus, and Santa Claus' opinion about Fannie Willis is ho ho ho, says Santa Claus. Okay, I will see you over there in 20 minutes. Okay, thank you for being here. Thank you for allowing me to try to translate this trial to you. Thank you for the super chats. Thank you. Hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. I'll see you in 20 minutes. Bye-bye.